Thank you. We move to Group 4, Information Gathering and Reporting in relation to rent control areas. I call Amendment 139 in the name of Maggie Chapman, grouped with amendments as shown in the groupings. Maggie Chapman to move Amendment 139 and speak to all amendments in the group.
Thank you, Presiding Officer, and I move Amendment 139 in my name. I have a number of amendments in this group on different issues. Amendments 139, 275 and 140, along with amendments in other groups, address a technical but important issue. Current challenges to rent increases are based on open market rent, as understood largely through advertised rent, not the actual rents being paid. Since the majority of advertised rents are set at the maximum the market will bear, open market comparison always drags rent upwards. Real rent comparison would ensure that rental data collected can be used for determining the open market rent and slow that ever upward creep of the open market rent if it doesn't use that real value. Amendments 30, 31, 32 and 33 increase the currently £1,000 fines for non-provision of information and provision of false information to a minimum of £2,000 and allow them to be increased with rising rents. These amendments underline the importance of getting the necessary and correct information, the issue which made rent pressure zones unworkable. At the moment, the bill's £1,000 fine, which may not even be 1 month's rent, is not a sufficient disincentive, and the incentive will become weaker over time if the fines are not updated. It is also clear that rents continue to rise, and therefore the penalties that landlords face for providing incorrect information or not providing information should also rise. I support the principle of Edward Mountain's amendments 141 and 142 and Graham Simpson's 151. These require the publication of the information gathered and will help improve transparency. However, I note that there are concerns about the resources, the implication for resourcing this at local government level, and I would ask that they provide assurances on that in their contributions. I'll leave it there, Presiding Officer. Thank you.
Thank you. I call Megan Gallagher to speak to Amendment 271 and other amendments in the group.
Thank you, Presiding Officer. If I may speak to Amendments 271 to 277 and 393 in my name firstly. These amendments introduce a clear and consistent definition of relevant landlord across all housing-related legislation, including the Housing Bill. Its aim is to ensure clarity over responsibilities for compliance, particularly where residential tenancies exist within agricultural holdings or other arm's-length ownership arrangements. This proposal addresses an issue repeatedly raised by Scottish Land and Estates since the introduction of the landlord registration regulations. The Housing Bill is a vital opportunity to fix a long-standing problem to the benefit of all parties. Under current housing law, such as the Antisocial Behaviour Scotland Act 2004, does not recognise landlord-tenant relationships created under agricultural holdings legislation. This causes confusion, especially when tenant farmers sublet housing under private residential tenancy (PRT) arrangements. Workarounds set out in government guidance is flawed. Tenant farmers are currently advised to register as agents on the landlord register. However, I do believe that this is inappropriate. As such, agents are meant to act on behalf of the owner, whereas tenant farmers are not required to do so under agricultural holdings law. This ambiguity creates uncertainty over who is responsible for compliance with data collection, rent control, energy efficiency and housing standards. Whilst the Housing Bill has already been amended to address some areas in relation to data collection, and I do believe we'll be having further discussions on that, it does not resolve compliance and enforcement for other regulations. There are benefits to the amendment that I'm submitting at stage 3 for all sectors involved. For local authorities, it allows accurate landlord registration and enforcement, ensuring the correct person is held responsible without penalising owners for actions beyond their control. For tenant farmers, it provides clarity on the responsibilities and rights without compromising the entitlement to compensation payable to them by the owner for any improvements made to enable subletting. For residential tenants, this amendment will provide clearer information on who is responsible for compliance and a straightforward route to any remedies required. For owners, this will increase confidence to allow subletting, knowing their compliance status is protected. If I may therefore address amendments 144, 145, 146, 147 and 148. These, of course, are consequential amendments to 271 to 277 to remove the potential confusion from the bill. If I may speak to amendments 275 and 140 in the name of Maggie Chapman. I do understand what Maggie Chapman is trying to achieve through these amendments, but there still are unanswered questions in relation to any potential consequences. For example, the amendments state that the Council may ask for data on a landlord's property to allow an order marker to determine an open market rent of a property. But I suppose the big question is, what happens if the landlord doesn't respond to that request, because the amendment does say may. So I think it's still very open to interpretation, and I don't believe that the amendments clearly set out what the intent is behind the amendments that Maggie Chapman is bringing forward. Amendment 149 in the name of Emma Roddick, the Scottish Conservatives, we will support Amendment 149 as it gives the Government the ability to look at legislation which would give councils and the government the requirement for landlords to provide information. Of course, I do believe that there will be further consultation in relation to these details which will need to be set out in regulation. However, it does seem reasonable and something which should be explored. Amendment 151 in the name of Graham Simpson. I do believe that data collection is vital as part of the bill. However, there was a roundtable opportunity with the Cabinet Secretary. I was pleased to have had correspondence in relation to data from the Cabinet Secretary in relation to what measures the Government will be undertaking in relation to data, and I do believe that we should continue to engage with the Government to make sure that we do get data collection in terms of this piece of legislation right, because if we don't get the data collection right, that will obviously have negative consequences on rent controls and, of course, negative consequences on our housing stock in general. I will leave my comments for now, Presiding Officer. Thank you.
Thank you, Ms Gallagher. I call Edward Mountain to speak to Amendment 141 and other amendments in the group.
Thank you very much, Presiding Officer, and I'll speak to my amendments first. 141 would require the information requested by a local authority and supplied by the landlord to be entered onto the landlord's register. It is absolutely vital in my mind that we don't continue to ask the same information time after time. It is an easy way and a slovenly way, in my opinion, of failing to keep a register that would happen. So I'd like to see local authorities entering that information on the roll, and for landlords having the ability to update it as and when they see it appropriate. I also don't think if we are asking landlords to provide information that there should be any cost for the landlords providing that information to the local authority. If we're going to fine them for not doing it, it seems odd that we would charge them for doing it in the first place. I have no problems with Amendment 139 from Maggie Chapman and Megan Gallagher's amendments. My slight concern is Amendment 275 and 140 from Maggie Chapman, the way she spoke to them. I'm not convinced, Presiding Officer, that Maggie Chapman understands the definition of open market. Now, it is quite clearly laid out that open market, when it comes to rent or prices, is the price achieved with a willing renter and a willing tenant without any obligations on any half. That would be my definition of open market rent, not open market rent as Maggie Chapman, presiding officer, is suggesting, is the highest rent that the landlord can achieve. They are two very different things. And I think if we're technically talking open market rent for property is as I've described it. I also think that Maggie Chapman's suggestions in amendments 30, 31, 32 and 33 of increasing the fine for landlords for providing data from £1,000 to £2,000 is absolutely unnecessary. And does that mean that every time that a landlord fails to provide any information, there's another £2,000 added on? Where does it stop? The amendment isn't clear. I'm looking forward to hearing Emma Roddick's definition and an explanation of 149.262. My gut thoughts on this is that we should be supporting it, but I'd just like to make sure there's nothing more in there than what's said in the amendment. And I guess the only other thing is I will be looking forward to hearing Graham Simpson's explanation of Amendment 151, whereas I'm probably more comfortable with his Amendment 263. And I'll leave it at that, Presiding Officer. Thank you.
Thank you, Mr Mountain. I call the Cabinet Secretary to speak to Amendment 143 and other amendments in the group.
Thank you, Presiding Officer. Amendment 139, beginning here in the name of Maggie Chapman, this would amend Section 15 of the Bill to oblige a local authority to request the information included in Section 15(2). This would remove the authority's discretion to ask for the information in the manner and at the times as it considers necessary, and for that reason I cannot support it. Amendments 271 to 274 in the name of Megan Gallagher appear to amend Section 15 of the Bill to change reference to the person from whom information can be sought, so that there are instead references to the relevant person. In addition, Amendment 276 would add a definition of relevant person to Section 15. Relevant person as a term is to be construed in accordance with Section 83(8) of the Antisocial Behaviour Scotland Act 2004. The intention behind this amendment, and I listened carefully to what Megan Gallagher was saying, appears to be that information should only be requested from a person who is registered in the Landlord Register. And I had some discussion to that effect with Scottish Lands and Estates, but I have to say that's not the effect of this amendment. The effect is that it would provide that information could be requested from anyone who is not a local authority, registered social landlord or Scottish Homes. So I'm afraid an unnecessary change, perhaps the wrong framing of the amendment, and it would only serve to confuse Section 15, so I can't support it. I will.
Megan Gallagher.
I'm very grateful to the Cabinet Secretary for giving way. Does the Cabinet Secretary recognise that there is an issue with the legislation as it currently stands in relation to some small dwellings holders who are being put out because of the way that the legislation is currently enforced? And does the Cabinet Secretary have any intention to rectify the issues in the bill, either through looking at this issue further or through secondary legislation?
Cabinet Secretary.
Thanks, Presiding Officer, and thanks to Megan Gallagher. So, as I said, I had a conversation with Scottish Lands and Estates about this and about the implications for agricultural holdings in particular. I understand their concerns. Taking this broad brush change to a definition I don't think is the way to address a nuanced position for agricultural holdings, but that's not to undermine the importance of it. And of course I'm committed to continuing to discuss that with Megan Gallagher and with Scottish Lands and Estates and others, and perhaps also with the Rural Affairs Secretary, who I'm sure will have an interest here. Turning to Amendment 140 and related Amendment 275 in the name of Maggie Chapman, I have concerns, Presiding Officer, about using the powers to collect information which are designed to assist in the implementation of rent controls for a completely separate purpose, as is proposed. There has been no consultation with landlords, tenants, local authorities or rent officers about this proposal, and no opportunity to consider the rationale, impacts and consequences of the change, so I'm afraid I can't support it. Amendment 141 in Edward Mountain's name would require the information requested on a private rented property to be added to the local authority landlord register. Now, just from the outset, I'm afraid this amendment has a slight drafting defect, as it presumably means the information received following a request by a local authority or the Scottish Ministers. It does not specifically apply the terms of Part 8 of the Antisocial Behaviour Act to this information. So, for that reason, it's not clear what status it would have on the Landlord Register and what the local authority's duties in relation to it would be. However, our intention is that the Landlord Register has a key role to play in facilitating the long-term collection of data on rent levels, acknowledging, as I do, that this gives us the capacity to build on an existing platform already familiar to landlords. This would involve using the Landlord Register's digital platform as a vehicle to collate the data. Now, it's important that I put on the record that the intention of the Government is not to change the purpose of the landlord registration requirements, but rather to use the IT infrastructure that supports registration. And while I believe this presents the optimum approach, it will require significant upgrade of the IT infrastructure to build necessary functionality. So I can't support Edward Mountain's amendments, but I do want to reassure him on my intentions here in relation to data handling, namely that I agree the Landlord Register with upgrades would appear to be the appropriate repository for information. Amendment 142, also in Edward Mountain's name, would add that a person must not be charged any fees, as he has explained. Given that the terms of the 2004 Act do not apply to this information, it's not clear how a local authority would be able to charge a fee, and as a result, I don't think this amendment is necessary and ought not to be taken forward. Amendment 277 in Megan Gallagher's name would require ministers to provide... yes, I shall.
Edward Mountain.
I thank the Cabinet Secretary for taking an intervention. My concern is that if you're suggesting in one breath that the local authorities can enter it in the Landlord Register, every time you put an entry in there, there's another charge applied to you by the Council, which seems to go up exponentially. So the principle of charging for putting stuff on the Landlord Register seems to be there. My concern is if you're now going to design a whole new system to bolt onto that, there'll be charges. Can you not just agree that no one should be charged for providing information to allow you to do your job, Cabinet Secretary?
Always through the Chair, please. Cabinet Secretary.
Presiding Officer, the principle of charging will vary from issue to issue, and I'm not going to say definitively how I think local authorities ought to handle what will ultimately be their job in respect of data collection. However, what I want to be very clear to Mr Mountain about is that his amendment responds to the 2004 Act, but given that the 2004 Act doesn't apply here, it wouldn't be possible to charge a fee, and therefore we can't accept the amendment which would reverse that. Amendment 277 in the name of Megan Gallagher would be requiring the Scottish Ministers to provide for the information gathered by local authorities to be published in a single data system. Again, whilst I agree with the principle of making data available, we have not been able to give consideration to how this would be delivered, and more importantly, whether there's any data protection considerations to be made around sharing such information. I would want us, as I'm sure Megan Gallagher would, I would want us to understand the relevant issues, not least in respect of GDPR and the landlord's privacy, and therefore at this stage I couldn't support an amendment which was about publicising that data. Yes, I will.
Megan Gallagher.
Secretary for giving way. The reason that I brought forward this amendment at stage 3 was through discussions with the Chartered Institute for Housing, who said the following: if the Scottish Government decides that a rent cap system should be introduced, it must ensure that the rent system is viable and adequately resourced. This includes provision for robust data collection. I do believe that that's perhaps what the Cabinet Secretary is alluding to into the work that she's going to undertake as part of creating a good data system where information can be collected. But does she agree that this needs to be streamlined? It's got to be contained within that single data system, and it's got to be easy for landlords to be able to feed into that, and as Edward Mountain said, without extravagant costs attached to landlords for doing their job.
Cabinet Secretary.
Presiding Officer, I would agree with that, and that's why I consider that the Landlord Register might be the suitable repository for the information. I have gone into the decision-making in respect of this with the thought in mind that if I were a landlord, I would want to, and had rent controls imposed in the area where I was letting, I would want to know that it was based on the most accurate and up-to-date data. But at the same time, I shouldn't want a unduly onerous process to have given rise to that. So at stage 2 we did bring forward an amendment that was agreed to allow for the publication of statistics and other information in relation to the information ministers will obtain. This will allow us to publicise information about rent levels which does not involve the publication of a landlord's personal information, and I would hope that Megan Gallagher would agree that that is the best way to proceed. Amendments 144 to 148, also in Megan Gallagher's name, would change the reference to relevant persons in 16A of the bill to relevant applicants. Again, I think this is similar to the discussion we had before in respect of the agricultural holdings provisions, but I'm afraid once again these amendments are confusing and they would make section 16A unworkable, and I can't support them. Amendments 30, 31 and 39 in the name of Maggie Chapman replace the maximum £1,000 penalty where a landlord fails to provide information in response to a request for under section 15 with a fixed penalty to be defined in regulations. Now, this fixed penalty can be set at no less than £2,000 and must be adjusted annually with reference to average rent levels. Ms Chapman did lodge a similar amendment at stage 2, but fixing a higher penalty of £10,000. So whilst amendments 30, 31 and 39 would impose a lower penalty, and I do welcome that, it would still be a fixed sum rather than a sliding scale. And this a maximum sum of £1,000, which is as it is at present. The maximum sum is aligned with financial penalties for similar non-compliance in other regimes, and I remain convinced that it represents a proportionate maximum penalty, and I am not prepared to abandon uniformity across the penalty system, and I'm seeking proportionality here. I will take an intervention and then I ought to make some progress.
Maggie Chapman.
I thank the Cabinet Secretary for taking my intervention. I just wonder, I hear what she says about consistency across the board, but is it not slightly odd that landlords can benefit from increasing rents, rents going up regularly if the government's position stands, but above RPI in a rent control area, but that the penalties they face for not providing correct information or providing incorrect information is just flat? Surely that makes it increasingly better for the landlord, if you like, to break the rules.
Cabinet Secretary.
Well, I certainly agree that nobody ought to flout or break the rules in respect of law or public policy, and that's exactly why we have provision for a penalty to be in place. So I don't dispute the principle of that whatsoever. I think Maggie Chapman and I's disagreement is just simply on whether it ought to be that fixed sum or that sliding scale with the Tribunal's discretion able to be applied. And I have to look across the piece at other penalties within the system and make sure that we retain proportionality, and that's why I can't accept that. And similarly, Amendments 32, 33 and 40 make the same changes to 17A, enabling a tribunal to impose a maximum £1,000 penalty where a landlord provides false information. And I believe that a penalty on a sliding scale up to £1,000 represents a proportionate response. Moving to Amendments 149 and 262 in Emma Roddick's name, these would add a new section to the bill empowering Scottish ministers via regulations to prescribe a process whereby a landlord can be required to provide relevant information about their property or tenancy to the Scottish ministers or a local authority, but not both. I'd like to thank Emma for her engagement on this following stage 2. Whilst the measures already set out in the bill allow for the collection of data that's needed to support implementation of rent controls, having the flexibility to mandate automatic provision of that data, I think is appropriate. And it goes back to something I said to Megan Gallagher earlier about, if we were landlords and we were to have rent control imposed on us, we would want it to be part of a predictable system, and actually an annual requirement to provide that data, I think, could provide that predictability. Nearly there, Presiding Officer. Amendments 151 and 263 in the name of Graham Simpson, they would require ministers to make provision requiring each local authority to publish information on the amount of rent payable under relevant tenancies, broken down by each postcode sector for each period of 12 months. Whilst I understand the principle of making data available, there has not been any consideration of how this would be delivered, and I would want us to understand the relevant issues, including the potential administrative burden that this would place on local authorities. Certainly to understand that before I could support an amendment on this. So I can't support that one, but as I've said, at stage 2 we did bring forward an amendment that was agreed that will allow for the publication of statistics and other information that is not personal data. Amendment 393 in the name of Megan Gallagher would amend section 81(3) of the Antisocial Behaviour Scotland Act to provide that an application for landlord registration must specify the name and address of the owner and the name and address of the relevant person. The amendment, I think, is attempting to require sub-landlords to apply for registration in the Landlord Register. However, I'm afraid the drafting is slightly defective and, taken literally, would require the application to include the address of each house in the local authority area that is subject to a lease or occupancy agreement, whether or not the applicant owns it. I suspect that wasn't Ms Gallagher's intention, but it means I can't support the amendment. Amendment 143 in my name is a minor amendment correcting a cross-reference in section 15.
Thank you, Cabinet Secretary. I call Emma Roddick to speak to Amendment 149 and other amendments in the group.
Thank you, Presiding Officer. As anybody who took part in Stage 2 knows, I have been really keen to see data collection strengthened. So often we find ourselves in this Parliament, and similar situations take place in councils across Scotland as well, debating private rented sector policy using data that's been scraped from Zoopla or estimated by people on either side of the debate, meaning that data naturally differs wildly. This serves nobody, and we end up taking positions based on anecdotes and guesses when the information is out there to be captured. What are people charging tenants, and for what kind of property? I strongly believe that an accurate picture of this will lead to better policy and greater confidence in decisions that are taken, whether you agree with them or not. There are examples in the debates around this very bill. I know that from Scottish Land and Estates there are concerns out there about the system of rent caps not taking into account these private landlords in rural areas who've protected their tenants over many years and are now renting below market rate. I don't know how common that is, and we will never know if we don't ask and require answers to be given. We also don't know the full scale of exorbitant rent rates that do exist. We usually only know of them once they're challenged. My Amendment 149 would allow Scottish ministers to set up a process through regulations requiring landlords to provide information about their property or tenancy, either to ministers or to the local authority. Unlike the existing powers in the bill, this would make it an ongoing duty for landlords, rather than being instigated by a request by Scottish ministers or the Council. Now, this requirement to provide the same information could not be imposed more than once a year, regardless of who is asking. The amendment outlines what the regulations could cover, such as when and how information is provided, how it is used and shared, and how the process is enforced, including an appeals process. This approach would give clarity about what is expected of landlords and reduce the need for repeated requests from government and therefore repeated answers from landlords. However, I recognise that this would be a significant new responsibility for landlords and could require more resources from government to manage the returns, which is why my more specific amendments at Stage 2 were rejected. That is why I've brought this forward as a regulation-making power which could be used if considered necessary and after engagement with those affected. My consequential Amendment 262 would ensure that any regulations made under this section are subject to the affirmative procedure, so Parliament has the opportunity to scrutinise them fully. Now, I suspect Edward Mountain would have disagreed with my initial proposals, just as Government did, but I hope that provides him with the reassurance that he was looking for, and I'm happy to take an intervention.
Graham Simpson.
I thank Emma Roddick for taking the intervention. I've just got one question. I wasn't sure about this amendment, but I'm quite taken by it now. As I said, I can change my mind. My question is, has Emma Roddick liaised with the Scottish Association of Landlords on this, and what's their view?
Emma Roddick.
I don't believe I've had correspondence with them specifically, but certainly during Stage 2 on much more forceful amendments that I had lodged at that point, there were landlord and tenant roundtables taking place in the Parliament, and there was widespread support from both sides. Even back then, with very different amendments on data collection, pretty much everyone was agreed that the current system, where we are guessing and people are having to put forward views, and it's difficult for government to uphold the decisions it's made. It's also difficult for people to challenge them when there isn't the data out there to back up either side of the argument. So I am grateful to... Certainly.
Edward Mountain.
Presiding Officer, I'd like to thank the member for taking the intervention, and of course the member is right and has correctly construed that I would not have supported her amendment when it was at committee stage. I just want to get an indication from you where you're going with this. Are you expecting it's something that, or is the member, sorry, Presiding Officer, I'll correct myself before you do, is the member looking to do this on an annual basis? Is it on every few years? Is there a standard form? I'm looking for some guidance which she would be expecting the government to follow when they were collecting this data. Thank you, Presiding Officer.
Emma Roddick.
It's a tough question because I'm not the government and I don't know what government's going to do with this. But my hope would certainly be that we look at situations and localities where we can get a good picture of what is going on across the country by collecting this data. I imagine that depending on the purpose and the reason for needing that data, that it would be best to have it as an annual, at least for a few years, to get that body of evidence. But like I say, it would depend, and I think the important part here is that this is going to be open for consultation, engagement and, importantly, parliamentary scrutiny. So I am grateful to the Cabinet Secretary for discussing this over the summer and reaching this position that gives ministers the power to, in future, design a process to collect better data. And I would encourage members across the chamber to support my amendments and then to please do what they can to ensure that this results down the line in real positive change in the data that we, government, landlords, lobby groups can rely on when making better law and policy in future. Because regardless of policy disagreements, we can surely agree that we need to have solid data and evidence backing up the decisions that we make. Thank you.
Thank you, Ms Roddick. I call Graham Simpson to speak to Amendment 151 and other amendments in the group.
Thank you very much indeed. Edward Mountain said he's looking forward to getting an explanation of 151. Now, it says that ministers must, by regulations, make provisions for councils to publish rent data, and 263 is a linked amendment. Data is a good thing, but when I lodged these amendments, in response to Megan Gallagher, I hadn't been invited to the round table that she was invited to, and which didn't actually take place due to lack of interest, I understand. I also hadn't had sight of the Cabinet Secretary's letter on data. I only saw that after I'd lodged my amendment. Had that been sent to me, I wouldn't have lodged this amendment. So I won't be pressing it because I have subsequently seen that letter. I'm reassured by it. And in relation to Emma Roddick's 149, I am persuaded. Ms Roddick often manages to persuade me on things, and she has done today. Thank you.
Thank you, Mr Simpson. And I call Maggie Chapman to wind up and press or withdraw Amendment 139.
Thank you, Presiding Officer. Fines should be a genuine disincentive to landlords to behave inappropriately. They cannot just be brushed off as an acceptable cost of doing business. Provision of accurate information is vital for renters. They should have access to clear, accurate and up-to-date information. To address the Cabinet Secretary's specific point about my amendments on fines, my amendments do not fix the fine level at £2,000. It quite clearly says in the amendment itself no less than £2,000 fine. So it too could be the sliding scale that she seems determined to maintain. We should also, Presiding Officer, be using this bill to rebalance that ever upward creep of open market rent, ensuring we collect and use real rental data to present a much more honest and reliable picture of the rental levels that tenants are exposed to. And this ask comes directly from tenants and tenants' organisations themselves. It is their experience and their analysis of open market rent to counter Edward Mountain's points earlier, that mean that there is this ever upward drag of that open market rent, because adverts will push as high as they possibly can. So with that, Presiding Officer, I move that amendment in my name.
Thank you, Ms Chapman. The question is that Amendment 139 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Neil Gray for a point of order.
Thank you, Presiding Officer. I couldn't connect to the app. I would have voted no.
Thank you, Mr Gray. We'll ensure that's recorded. The result of the vote on amendment number 139 in the name of Maggie Chapman is yes 48, no 63. There were no abstentions. The amendment is therefore not agreed. I call amendments 271, 272, 273 and 274, all in the name of Megan Gallagher and all previously debated with amendment 139, and I invite Megan Gallagher to move amendments 271 to 274 en bloc.
Moved en bloc, Presiding Officer.
Thank you, Ms Gallagher. Does any member object to a single question being put on amendments 271 to 274? No member objects. The question is that amendments 271 to 274 are agreed to. Are we all agreed? The Parliament is not agreed. Therefore, we will move to a vote, and members should cast their votes now. The vote is closed. The result of the vote on amendments number 271 to 274 in the name of Megan Gallagher is yes 43, no 67. There were no abstentions. The amendments are therefore not agreed. I call Amendment 275 in the name of Maggie Chapman, already debated, with Amendment 139. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 275 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Keith Brown for a point of order.
For my vote, Presiding Officer, I would have voted no.
Thank you, Mr Brown. We'll ensure that's recorded. The result of the vote on amendment number 275 in the name of Maggie Chapman is yes 48, no 62. There were no abstentions. The amendment is therefore not agreed. I call amendment 140 in the name of Maggie Chapman, already debated, with amendment 139. Maggie Chapman, to move or not move?
Moved.
The question is that amendment 140 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 140 in the name of Maggie Chapman is yes 46, no 62. There were no abstentions. The amendment is therefore not agreed. I call amendment 141 in the name of Edward Mountain, already debated, with amendment 139. Edward Mountain, to move or not move?
Moved.
The question is that amendment 141 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 141 in the name of Edward Mountain is yes 42, no 60. There were 7 abstentions. The amendment is therefore not agreed. I call amendment 142 in the name of Edward Mountain, already debated, with amendment 139. Edward Mountain to move or not move?
Moved.
Thank you. The question is that amendment 142 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 142 in the name of Edward Mountain is yes 26, no 77. There were 7 abstentions. The amendment is therefore not agreed. I call amendment 276 in the name of Megan Gallagher, already debated, with amendment 139. Megan Gallagher to move or not move? The amendment is moved. The question is that amendment 276 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 276 in the name of Megan Gallagher is yes 41, no 68. There were no abstentions. The amendment is therefore not agreed. I call amendment 143 in the name of the Cabinet Secretary, already debated, with amendment 139. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that amendment 143 be agreed to. Are we all agreed? Yes. We are agreed. I call amendment 277 in the name of Megan Gallagher, already debated, with amendment 139. Megan Gallagher to move or not move? Not moved. Okay. The amendment is not moved. I call amendments 144, 145, 146 and 147, all in the name of Megan Gallagher and all previously debated, with amendment 139. And I invite Megan Gallagher to move amendments 144 to 147 on block.
Moved on block, Presiding Officer.
Thank you. Does any member object to a single question being put on amendments 144 to 147? No member objects. The question is that amendments 144 to 147 are agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Co-Cap Stewart for a point of order.
Wouldn't connect. I would have voted no.
Thank you, Ms Stewart. We'll ensure that's recorded. The result of the vote on amendments numbers 144 to 147 in the name of Megan Gallagher is yes 43, no 67. There were no abstentions. The amendments are therefore not agreed. I call Amendment 30 in the name of Maggie Chapman, already debated with Amendment 139. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 30 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 30 in the name of Maggie Chapman is yes 24, no 85. There were no abstentions. The amendment is therefore not agreed. I call amendment 31 in the name of Maggie Chapman, already debated with amendment 139. Maggie Chapman, to move or not move?
Not move.
Thank you. The amendment is not moved. I call amendment 148 in the name of Megan Gallagher, already debated with amendment 139. Megan Gallagher, to move or not move?
Not moved.
Thank you. I call Amendment 32 in the name of Maggie Chapman, already debated with Amendment 139. Maggie Chapman, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call Amendment 33 in the name of Maggie Chapman, already debated with Amendment 139. Maggie Chapman, to move or not move? Thank you. I call Amendment 149 in the name of Emma Roddick, already debated with Amendment 139. Emma Roddick, to move or not move?
Moved.
The question is that Amendment 149 be agreed to. Are we all agreed?
Yes.
The amendment is agreed. I call Amendment 150 in the name of Maggie Chapman, already debated with Amendment 123. Maggie Chapman, to move or not move?
Moved.
Thank you. The question is that Amendment 150 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 150 in the name of Maggie Chapman is yes 8, no 101. There were no abstentions. The amendment is therefore not agreed. I call amendment 151 in the name of Graham Simpson, already debated with amendment 139. Graham Simpson, to move or not move?
Not moved.
The amendment is not moved. Members will note that we will shortly reach the next time limit, and we have two further groups still to debate under Rule 9.8.5a. I'm minded to accept a motion without notice to propose that the time limit be extended by 30 minutes, and I invite the Minister for Parliamentary Business to move the motion.
Move, Presiding Officer.
Thank you, Minister. And the question is that the time limit for debate on amendments be extended by 30 minutes. Are we all agreed? We are agreed. We move to Group 5, Special and Transitionary Rent Control Provisions, and I call Amendment 1 in the name of Maggie Chapman, grouped with Amendments 2, 6, 22, 118, 23, 24 and 120. Maggie Chapman to move Amendment 1 and speak to all amendments in the group.
Thank you, Presiding Officer, and I move Amendment 1 in my name. Amendments 1, 2 and 22 introduce special rent control areas. These work much the same way as rent control areas, but would allow rents to increase by a lower amount than specified in the central formula, to be frozen or to be cut. This is absolutely crucial. Rents have increased by grotesque amounts in some areas of Scotland, over 100% in some cases since 2010, and the central formula would do absolutely nothing to address this. In Glasgow, in Lothian and in some other areas with recent large increases, there will be a very strong case to apply short-term controls which allows much tighter limits on rent than the current proposal of RPI plus 1% up to 6%. If we don't do this, we are essentially endorsing the unacceptable increases we have seen in recent years. Considering that tighter controls require stronger safeguards, I have already limited the lifetime of the special rent control areas to 1 year. But I hope we can agree on the principle that there will be some areas in which tighter controls will be temporarily needed. Amendments 24 and 122 seek to reinstate the transitional provisions that offered some protection to tenants ahead of rent control areas coming into force. These were meant to act as a bridge to the bill's controls, and it makes absolutely no sense for those to have lapsed. The Scottish Government, which support rent controls, is allowing rents to soar in the 2 years before the bill comes into force. In the time since the controls expired, just in March this year, Living Rent has documented cases of renters facing huge hikes far and beyond market rate, with some landlords proposing above 30% rent increases, some up to 88% hikes. A Living Rent Lanarkshire member faced a 55% rent increase this summer, whilst one of the members in Glasgow was hit by a £200 increase. That's £2,400 over a year. How is an average renter expected to be able to cope with such ludicrous rent hikes? Allowing these controls to lapse does not make sense for a government whose official position is that it supports rent controls. It does not make sense for a government that is seeking to reduce child poverty, with housing costs one of the biggest contributors to that. It does not make sense for a government committed to eradicating homelessness to allow years of a near free-for-all for landlords to hike rents beyond what some people will be able to afford. My understanding is that the Scottish Government has been advised that it would likely lose a legal challenge on this issue. The Scottish Government has not been backward about coming forward to go to court to defend policies before now. It stood up for the rights of our trans siblings to define to be known by their preferred gender, and it stood up for the right for Scotland to vote on its future as an independent country. I'm asking for it to do the same now. Stand up for renters and be prepared to defend their rights not to have exorbitant rent hikes before rent controls areas come into force. Thank you.
Thank you, Ms Chapman. I call Megan Gallagher.
Thank you very much, Presiding Officer. I wish to speak to Amendments 1 and 2 in the name of Maggie Chapman. The creation of a special rent control area where the permitted rate of increase would be even lower, with the permitted rate potentially being 0% or less, meaning no increase or even a reduction in rent. The Scottish Greens have already made their feelings known, that they do not believe that the rent control scope goes far enough, further highlighting that they do not understand the housing sector and the precarious situation that we find ourselves in with landlords leaving the market. And it is this anti-landlord rhetoric from politicians that is partially to blame for landlords leaving the sector. And since 2016, the Scottish Association of Landlords have estimated that 35,591 have exited the register, bringing numbers down to their lowest level in a decade. We need investment. We need landlords to stay in the market if we're going to make sure that we have enough demand of homes to meet supply. That's why we really need to be careful in terms of the amendments that we are bringing forward at stage 3, and to create special rent controls will only lead to more landlords exiting the market. I don't think that introducing varying rent controls will solve any of the issues that Maggie Chapman seeks to with these amendments. I think it will only create an uneven picture, and it will also deter developments from proceeding in terms of any future investment opportunities. And for these reasons I have outlined, Presiding Officer, the Scottish Conservatives will not support any amendments that will cause further harm to our housing sector. Thank you.
Thank you, Ms Gallagher. And I call in the Cabinet Secretary.
Thank you, Presiding Officer. The issues raised by Maggie Chapman in this group were debated at stage 2 and have also been the subject of much wider discussion. I should just like to, I suppose, reflect on some of her comments to start with, and to say that from the offset, the Government absolutely is determined to tackle what we entirely acknowledge have been unacceptably high and increasing rents. That's exactly why we are bringing in rent controls. We are also determined to tackle the housing emergency. That's exactly why on the 2nd of September we brought forward a housing emergency action plan backed by nearly £5 billion and have launched a major house building project over the next 4 years. So we really must be clear-eyed about what the Government is pursuing here. But if I can turn firstly to Amendments 1, 2 and 22, these would provide for the introduction of that special rent control area. And as has been set out, in these areas, a rent cap could be set for up to 1 year, which would be below the level of the rent cap of CPI plus 1%, up to a maximum of 6% that was agreed by the committee at stage 2. These amendments, which were also lodged at stage 2, would enable the rent cap in a special rent control area to be set at 0%, or put another way, a negative figure. This would require landlords to reduce rent in some circumstances. Now, it's not the policy intention that rent controls should act to require landlords to reduce rent, rather that the system will act to stabilise rents in areas where market rents have been increasing particularly steeply. Requiring the reduction of rent would be a significant interference in the property rights of landlords and would be very difficult to justify and enforce. And I know Maggie Chapman spoke about a willingness, as she put it, to be challenged and to end up in court. But that doesn't serve us in having rent controls operating in the country if that's the approach we were to take. So these amendments would remove the clarity of the rent cap and would reintroduce the uncertainty that stakeholders called on us to address. So for these reasons, I can't support 1, 2 and 22. Amendments 6, 118, 23 and 24 would reintroduce the temporary modifications to rent adjudication set out in the Rent Adjudication Temporary Modifications Scotland Regulations of 24. These expired at the end of March. Now, I recognise the good intent behind these amendments that were also lodged at stage 2 and the desire to protect tenants from unreasonable in-tenancy rent increases. However, I cannot support these provisions for a number of reasons. And I must note that the circumstances which necessitated the introduction of the temporary changes no longer apply, and the judicial review of the measures under the Cost of Living Act emphasised their temporary nature as being a key factor in their proportionality. The temporary modifications to the rent adjudication process, which these measures replicate, were developed specifically to support the transition away from the emergency rent cap They were in place to prevent a return to market rent in a single step where a tenant sought a review. They were not designed or indeed able to operate until new rent controls become operational under Part 1 of the bill. And I will take Mercedes Villalba.
Mercedes Villalba.
Thank you very much for taking the intervention. I thought I heard the Minister say that the circumstances no longer apply under which the emergency rent freeze came into force, but that came into force because we were seeing a cost of living crisis. Is the Minister saying that cost of living crisis has now passed?
Cabinet Secretary.
No, I'm absolutely not saying that. I was referring to the fact that the process was developed specifically to support the transition away from the emergency rent cap. That was the circumstances that I was suggesting no longer apply. I am absolutely aware that the cost of living crisis is continuing, getting worse in many cases, not least because of rising energy costs. But for all the reasons that I've set out, I can't support the amendments. But I want to assure Maggie Chapman that the existing mechanism for adjudicating rent increases under the 2016 Act, which is based on an open market rent, will continue to operate as intended, protecting tenants from unreasonable rent increases. I now turn quickly to Amendment 120, which suggests an alternative approach to transitional rent control measures. Whilst these measures were necessary as part of exiting previous emergency measures, I can't support replicating them, placing further temporary controls on rent, especially when we're trying to bring forward that long-term system. Now, whilst I appreciate it would be up to Scottish Ministers to set out the detail of these regulations, the rationale that supported the development of them, as I have said, no longer applies. We are no longer in that transitionary period. And as I've stated, and will reiterate again, these measures were temporary. There has been no engagement with the wider sector about their reintroduction, and it may have wider legal implications. So I know that these amendments, if passed, would cause further concerns about the negative impact on the supply of rented housing, and this is something which, in a housing emergency, I certainly couldn't support, and I don't think our housing system could withstand. So I want to be clear that we're already taking action to prevent a rent officer of the tribunal setting a rent above that proposed by the landlord. Missed the spot, Presiding Officer, forgive me. We've listened to the views of the landlords, tenants and investors in developing proposals for longer-term rent control, and I believe the focus should remain on delivering that, and that there's a risk that a change to this could undermine the progress that we're making. And I also want to be clear that we're already taking action to prevent the rent officer or tribunal from setting rent above that proposed by the landlord. That's a concern that's been shared with us, it's being addressed in this bill, and it's another reason why I can't support amendments in this group and would urge members not to as well.
Thank you, Cabinet Secretary. I now call Maggie Chapman to wind up and to press or withdraw Amendment number 1.
Thank you, Presiding Officer. This Parliament brought in emergency rent controls to provide tenants with protections during the cost of living crisis. As has already been agreed in response to Mercedes Villalba's question, the Cabinet Secretary agreed the cost of living crisis still exists. That is why we need the provisions in particular circumstances, in very, very clearly defined and time-limited circumstances, to be able to reintroduce special rent controls that do bring rents down. Because the formula that is in the bill at the moment means that rents will always increase more quickly than inflation. That does not make rents more affordable in the long term. Rents will increase at a greater rate than people's wages, than people have the ability to pay. The special rent control area provisions would mean that we could deal with that in very specific, limited and time-constrained circumstances. On transitional protections, the Cabinet Secretary has said that it is the Scottish Government's intent to stabilise rents. Well, we've seen anything but stabilisation in the months since the end of March this year. We've seen rents go up to nearly 90%, being increased by nearly 90%. That is not stabilisation. That makes those rents grossly unaffordable, and it means that when rent control areas do come in, they'll already be, in some places, unaffordable. The Cabinet Secretary also refers to rent adjudication and tribunals. That requires tenants to know that that's a possible route, and we still haven't got clarity on exactly how renters and renters will get that information. So I think when taken together, it is actually really important that we have the ability to introduce special rent control areas and to reintroduce these transitional protections to make sure that renters aren't paying the price for the fact that this bill has been so woefully delayed.
And Ms Chapman?
And Amendment 1 in my name.
Thank you, Ms Chapman. The question is that Amendment number 1 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on Amendment number 1 in the name of Maggie Chapman is yes, 8, no, 96. There were no abstentions. The amendment is therefore not agreed. I call Amendment number 2 in the name of Maggie Chapman, already debated with Amendment number 1. Maggie Chapman, to move or not move? Not moved. So we now turn to Group 6 on rent controls within rent control areas. I call Amendment 152 in the name of the Cabinet Secretary, grouped with amendments as shown in the groupings. I point out that if Amendment 165 is agreed to, I cannot call Amendment 166 by way of preemption, and I call on the Cabinet Secretary to move Amendment 152 and to speak to all amendments in the group. Cabinet Secretary.
Presiding Officer, I move Amendment 152. Ahead of Stage 3, I have engaged with members across the Chamber and I'm very grateful for their input, and as a result I'm bringing forward some amendments to enhance the rights of tenants in the private rented sector. My Amendment 155, along with 152, will require certain information to be included in an advertisement when an exempt property is advertised for let. This would ensure that prospective tenants are aware before they take on the tenancy in a rent control area if their rent will not be governed by the rent cap. While analysis of our recent consultation is ongoing, the interim partial analysis, which we recently published, notes that a substantial majority of respondents thought that the landlord of an exempt property should be required to communicate to tenants and prospective tenants about the exemption, and this is exactly what my amendment applies. Amendments 74 and 121, also in my name, would allow for the creation of a process by a regulation whereby the first-tier tribunal could impose either a financial penalty or a compensation payment which would be payable to the tenant in cases where a landlord is found to not have complied with the requirements of the rent cap. These regulation-making powers would allow the first-tier tribunal full discretion as to whether to impose a penalty or compensation payment on the landlord and at what level to make this. Now, as a matter of principle, I think it's important to have repercussions for breaches of public policy and law, and I know from exchanges at Stage 2 and with members subsequently that many members agree. I believe that these measures will help to protect tenants, and I would urge members to support them. Turning now to amendments brought by other members, 165 and 167, in the name of Maggie Chapman, would amend the rent cap formula introduced into the bill at stage 2. 165 would provide that the permitted rate of rent increase specified in the legislation would be the lower of CPI percentage, the ASHE percentage or the AWE percentage. This modified formula would replace that which was agreed by the committee. Amendment 167 provides that an alternative lower percentage could be set by Scottish ministers in specified circumstances under new powers conferred by Amendment 171, and Amendment 196 would provide a definition of these specified circumstances. Ms Chapman's Amendment 168 would provide definitions of the terms used in 165. The ASHE percentage is defined as the difference in the median weekly earnings, and the AWE percentage is defined as the difference in the average weekly earnings over the preceding 12 months. Now, as set out at stage 2, wage growth is not a direct measure of changes in household income, since it excludes changes in hours worked and income from self-employment, social security and other assets. There are other complexities relating to these measures, such as the data from the annual survey of hours and earnings being published only once a year with a significant lag. While average weekly earning data is published on a monthly basis, the headline measure, which includes bonus payments, can be volatile. I'm just going to cover the rest of this piece because I just want to get this information on the record, and then I absolutely will. Furthermore, it's not a measure of rates of pay, since it can be affected by changes in the composition of an enterprise's workforce, such as the proportion who work full or part-time. So we don't consider that the available wage growth indicators, as proposed in these amendments, are robust enough to provide a reliable link between wages and tenants' income to sufficiently reflect the cost of maintaining a household or provide clarity on the costs that tenants are likely to face. Measures of wage growth are also unlikely to fully reflect costs which landlords may face. Against all of this, and I'm just about to take the intervention, the Consumer Price Index is published monthly and reflects the price increases experienced up to the prior month. It's a well understood measure, it has widespread use, and it will also correlate with price pressures faced by both tenants and landlords, and it's therefore a transparent, easy to understand formula which I believe we should stick with. And I'll take the intervention.
Maggie Chapman.
I'm grateful to the Cabinet Secretary for taking my intervention and for running through her rationale for that. She said wage inflation was not a reliable measure of household income. Does she then think that CPI is a reliable indicator of either household expenditure or household income? Because it's not.
Cabinet Secretary.
I think I've been clear on the strengths, as I see it, of CPI versus the other proposals that Maggie Chapman has made. And I actually think that one of the most important of them is the frequency with which it's published, and the fact that it reflects price increases up to a very recent period, up to the month before. And you know, again, it's well understood. It correlates with price pressures faced by tenants, importantly, but also by landlords. And for all those reasons, I do believe that it remains the appropriate way to measure this. And of course, it was voted on at stage 2. So for these reasons, I can't support Maggie Chapman's amendments. But moving to 170, also in her name, this would remove the provision preventing the rent cap dropping below 0%. It removes the Scottish Minister's power to substitute the percentage values in the rent cap, and it would replace with a power for us to specify a lower percentage than that in the fixed formula, and to specify the circumstances in which that percentage should apply. Now, as the percentage specified may be less than 0%, this amendment would open up, as before, the possibility of rent decreases, which is not, as we've discussed, the intention of rent controls, which are about stabilising rents that are rising too quickly. Amendments 72 and 73, also in Maggie Chapman's name, extend the deadlines from 21 days to 30 days for a tenant in a rent control area to notify a landlord that they consider a proposed rent increase to be in excess of the rent cap. The members brought forward a number of amendments at stage 2 seeking to increase the amount of time that a tenant would have in these circumstances. I think this timescale offers the best balance between protecting tenants and ensuring there's centred clarity for all parties, and therefore I am happy to support Amendments 72 and 73. Turning to 281 and 282, the bill includes a power for ministers to prescribe a fee to be charged when a tenant refers a proposed rent increase to a rent officer to determine whether the increase would be above the cap. These amendments in the name of Maggie Chapman would remove the power of the ministers to prescribe such a fee for rent verification within a rent control area. Now, the inclusion of the power is intended to provide ministers with flexibility to prescribe that fee if, once the provisions are in operation, this becomes necessary to support their operation, and actually they're about facilitating this process. And of course, a similar provision exists in the Private Housing Tenancies Scotland Act 2016 in relation to rent adjudication, although it has never been used. So I can't support this amendment, but I hope Ms Chapman will be reassured by the rationale and the fact that similar powers haven't been used. Amendments 34 to 36 and 41 to 43, also in Maggie Chapman's name, several of which are substantially similar to amendments brought at stage 2 on the issue, would not be required if my Amendment 74 and 121 are accepted, whilst Ms Chapman's amendments would, on the face of the bill, require that a rent officer issue an order for a landlord to pay compensation to a tenant where it's determined that a proposed rent increase is above the cap. The power conferred by Amendment 74 offers a more flexible approach, which allows for financial penalties and compensation to be provided in cases where it may be appropriate and proportionate, following consultation with landlords and tenant. And I hope that this amendment can gather support as a proportionate way to do much of what Maggie Chapman had been intending. Now, Amendment 166, in the name of Edward Mountain, alters the rent cap formula from the CPI percentage plus 1 to CPI plus 2 percentage points. Now, we've discussed much about the CPI percentage, but that formulation of CPI plus 1 is in line with what stakeholders in the sector have been calling for. Stakeholders, including the Scottish Property Federation and the Association for Rental Living, they welcomed the clarity provided by our statements in October and to the agreement that the committee made at stage 2. We set out at stage 2 that allowing some margin over inflation would give investors assurance. I still consider that this is the best approach, and that keeping that margin at 1% does what I have been seeking to do throughout, Presiding Officer, which is about balancing and seeking proportionality and affordability. Now, just to clarify, I can't support those amendments. Moving to 175, in the name of Edward Mountain, this would remove the requirement that rent increase notices for private residential tenancies in rent control areas should set out the reasons for the proposed rent increase. This was inserted at stage 2. As we made clear at stage 2, we believe that requiring all landlords of relevant tenancies in rent control areas to provide this information to tenants when they're increasing the rent is an unnecessary intrusion into the landlord's privacy with no obvious benefit to the tenant. Now, while tenants in a rent control area will be able to challenge a proposed rent increase on the basis that it doesn't apply with the cap, the reason that the rent increase is not a factor in these considerations, the reason for the rent increase ought not to be a factor. Such information would therefore not be helpful to the tenant, it would largely be irrelevant and would have no bearing on the decision at the end of the day. Mark Griffin's Amendment 280 is similar to a Stage 2 amendment, which would have changed the definition of rent for the purposes of rent increases in a rent control area, and we've discussed this before, Presiding Officer, in that it would exclude amounts payable to the landlord in respect of a number of utilities from the definition of rent. And Mark Griffin knows that my principal concern with this is that it takes the cost of utilities out with the protection that would otherwise be afforded to it if it were still within the definition of rent. And as such, I have significant concerns about Amendment 280 and its potential to undermine tenant protection. I'm sure Mark Griffin wouldn't want to pursue that. I'd ask him not to press it, and I can't support it. And to conclude, happily, Presiding Officer, I'd urge members to support my amendments in the group, along with Maggie Chapman's 72 and 73 and Edward Mountain's Amendment 175, but to reject the other amendments in my name, in the name of Edward Mountain, Maggie Chapman and Mark Griffin. Thank you.
Thank you, Cabinet Secretary. I call Maggie Chapman to speak to Amendment 165 and other amendments of the group. Ms Chapman.
Thank you very much, Presiding Officer. In many ways, this is the most important part of the bill. If passed, the provisions in this part will introduce the first rent controls in Scotland for almost 4 decades. Another Maggie took them away. I'm proud to be a Maggie in a team of people bringing rent controls back. And they could not come a moment too soon. Since 2010, rents for a 2-bedroom property have increased by 61% across Scotland, but by 82% in Glasgow and a staggering 104% in Lothian. Has the quality of properties soared to match those rent increases? No. Have people's wages in Lothian gone up by 104%? No. This is a sign of a fundamentally out-of-control private rented sector. Amendment 165 and its consequentials change the formula the Scottish Government has proposed, which will cap rents at CPI plus 1% up to a maximum of 6%. My alternative is to cap rents at the lowest of CPI or earnings growth up to the same maximum of 6%. This is an important principle. I've asked Spice to model both of these formulae. The green version makes a small but significant difference to rents in most areas, though a bigger difference in others. In Glasgow, had it been applied since 2019, rents would be, on average, £19 a month lower than had the Scottish Government's formula been in place. But in Aberdeen and Aberdeenshire, £66 per month lower. For many renters struggling on low incomes and with the rising cost of living, this would have represented a huge help to them. Importantly, these amendments establish an absolutely critical principle that rents should match people's ability to pay. If the earnings and living standards of renters are not increasing, neither should those of landlords. If landlords' incomes rise more quickly than renters, there is nothing more than a pure extraction of wealth from those on lower incomes by those with the privilege to own property. And this is not something Greens have made up. Shelter England have proposed precisely the same system for England. Raising rents 1% above the cost of living is simply not acceptable, and the 2% proposed by Edward Mountain even more so. We should not be locking in above inflation increases, which is what the Scottish Government and the Conservatives are trying to do. 169 and 171 allow ministers to specify exemptions to the formula to allow lower increases, a freeze or a decrease. I've already spoken to this principle in an earlier group, but I've tabled these amendments to recognise that in areas of Scotland, rents have gone up by as much as 100% in the last 15 years. And even a small increase would simply pile misery on top of this. In these cases, a smaller increase, a freeze or a cut would be essential. Amendment 282 ensures that fees cannot be required for a rent notice to be challenged. I appreciate there may not be any intention to do this at the moment, but a fee would be a barrier to challenging a rent increase, so we must remove the possibility of this happening in the future. This is about future-proofing our legislation. Amendments 72 and 73, which I'm pleased have Scottish Government support, extend the deadline for tenants to challenge a rent increase from 21 to 30 days. My earlier amendments set a much longer deadline, and I would in truth have preferred that, but the 30 days is an improvement, and I'm grateful to the work that I've been able to do with the Scottish Government on these. Taken together, Presiding Officer, this section of the bill and my amendments are crucial to making rents more affordable for people everywhere in Scotland. We cannot allow on the goodwill of others to bring rents down. Sometimes we have to legislate. Thank you.
Thank you, Ms Chapman. I now call Edward Mountain to speak to Amendment 166 and other amendments in the group. Mr Mountain.
Thank you very much, Presiding Officer. And I just want to say at the start of this, again, some of the language that I'm hearing is not what I believe happens in the rented sector. I don't believe it's out of control. It might be in areas that Ms Chapman knows, but it's certainly not in the areas that I represent, in the sense that a lot of landlords are trying desperately hard to increase the standard of the housing stock. And I don't think people give landlords credit for the amount of work that needs to be done. If you look at the prices to try and upgrade a, say, 1950s stone house, maybe up to £40,000. And if rents for those sort of houses, which is not uncommon in the Highlands, is at £600 per calendar month, it's going to take a huge amount of time to pay it back. And I accept, and I will accept the point that Ms Chapman makes I take it as a huge privilege of owning property, but I take it as a huge responsibility. And I take my responsibility, as many landlords do, to their tenants extremely highly. And just as a matter that may amuse Ms Chapman is that the only house that I own that doesn't have double glazing is my own, because I can't afford to put it in, but I've made sure every single one of the tenants has. And I think that's the way that a lot of landlords react. Now, turning to the amendments in case, I would like to start off with Amendment 166, which is mine. The reason why I'm suggesting a 2 percentage point increase is there are, as I've just alluded to, huge costs coming down the line, whether it be a heat source, air source, pumps that are going to be required to replace oil or gas boilers, if that's all there is. That's going to be a huge cost. And I've argued this with the industry, but we're all agreed that it's probably going to be a minimum of £15,000. And if you add on top of that the painting of the house, the rewiring that may be required, there are considerable costs. And I remember, and Mr Harvey may shake his head, I remember showing to Mr Harvey, presiding officer, when he was the Housing Minister, the costs of an EPC upgrade that he was looking for and evidencing them, which I know he discounted, but I would say that they're based on my experience as a surveyor and also a landlord. So I think there are huge costs. I will just in a minute, if I may, Ms Fialba, I'll come to you. I think there are huge costs, which is why I wanted to see whether there was the ability to allow landlords to go to 2 percentage points where they are doing improvements. I give way, presiding officer, to Ms Fialba.
Thank you. I'd like to ask the member a question. Why does he feel that the cost of improving and increasing the value of a privately held asset should fall on tenants?
Edward Ranton.
Well, you know, where does the cost lie? You know, if you're going to say that the cost may be £40,000 for a property and a 2% increase above RPI, so say it's 5% and 5% on £700 calendar month, I'm sure the member will be able to do that. It's £35 is all you're looking for as a contribution to the calendar month for a landlord who maybe have introduced £40,000 into doing that house. There is some benefit to the tenant. I'm not saying that the tenant needs to pay for it all. Far from it. I'm saying there is some contribution. And where I do agree with the Cabinet Secretary on this is that I do believe that CPI is the right level to use. It is well recognised throughout the industry. It's recognised, in fact, in all sectors. And it took me a bit of time to look up exactly what the other ones that were suggested by Ms Chapman in amendment and defined in Amendment 168. So I would agree with the Cabinet Secretary on that. Amendments 173 and 174, I'm not sure I heard the Cabinet Secretary speak to those, presiding officer. She may have skipped over them accidentally. But my point here, just in case at the end, when the Cabinet Secretary comes to sum up, is that the tenancy can be ended in the first year or can be ended with 6 months' notice. And therefore, what I was suggesting, that if a reduced rent had been given, that there ought to be the ability to reconfigure it after 6 months if the tenant leaves early. I think that makes sense. I do welcome the Cabinet Secretary's acceptance of my Amendment 175, the first one today, and there's always a bit of cheer when you get your first amendment through. I agree with some of the other Cabinet amendments from the Cabinet Secretary thing. I'm unclear about Amendments 170 and 171 lodged by Ms Chapman, presiding officer, in the sense that I'm not clear if that suggests that the rent should actually go down. It is suggesting, presiding officer, I've seen a nod. I'm not sure that that's ever going to be realistic, because I'm never sure that prices go down year on year. They never seem to have done since I've been alive, but that's only for 64 years at the moment, 65 years next year, presiding officer. And so I'm not sure that I've ever seen prices come down. And I think, presiding officer, there's a lot more I could talk about there, but I think I'm going to leave it at that on the hope that I've got one win, and with the Cabinet Secretary missing out 2 of my amendments, I may get 3 wins. Thank you, Presiding Officer.
Thank you, Mr Mountain. I now call Mark Griffin to speak to Amendment 280 and other amendments in the group. Mr Griffin.
Thank you, Presiding Officer. This amendment seeks to clarify that charges for domestic services such as water, sewerage, gas, electricity, broadband and district heating are not premiums and should be treated separately from rent. To ensure clarity and fairness in Scotland's rental market, it is essential that these service charges are explicitly excluded from the definition of a premium, and that would provide complete transparency for rent officers, letting agents and, most importantly, for tenants themselves, clearly separating occupancy costs from service charges. It also addresses a current gap where published market rents often obscure whether utilities are included, making comparisons unreliable and undermining the effectiveness of rent control. But I think the crucial point with this amendment here is actually it was lodged to align with existing legislation in section 9(5)(a) of the Housing Bill, but given the Cabinet Secretary's Amendment 64 has removed section 9(5)(a) from the bill, then I don't intend to press this amendment. Thank you.
Thank you, Mr Griffin. I now call Willie Rennie.
Thank you, Deputy Presiding Officer. For me, this is about moderation when it comes to setting the formula for rent controls. I think we're trying to seek a balance between fairness for tenants, but also certainty for investors. And I want investors in this sector, as I've already set out. I think the CPI+1 is a reasonable way to do it. You could argue about using other formula, but I think the Cabinet Secretary has set out a reasonable case that the more monthly, more regular reporting on the CPI means that we can get a more accurate figure when it comes to setting the formula. So I think that's a reasonable way to proceed, together with the exemptions that we've already discussed earlier. I think will provide that certainty for investors that we want. For me, we've been debating this for a long time. We've been debating this all the way back through to the temporary rent controls that we put in place. And that has created an awful lot of instability for investors, and we've seen the effect of that, not just with housing associations pulling out of the mid-market rent sector, but also the potential investment in other areas as well. So I would argue, as soon as we can get this bill through, as soon as we can get the exemptions in place, the sooner we can create that stable and political and regulatory environment for investors. Because I know, having spoken to many of them, they are keen to get on. They think potentially the environment is there to invest and build. And as I said earlier on, I am desperate to get new homes built so that we can get homes for people who are desperate for them in Scotland.
Thank you, Mr Rennie. And I call Alexander Stewart.
Thank you, Presiding Officer. Speak with reference to Amendments 165 to 170 from Maggie Chapman. Scottish Land and Estates have advised that linking rent caps with wages and earnings is not suitable for Scotland's diverse private rented sector, and I fully agree with them. The sector itself has a wide range of property types, tenancy arrangements and landlord profiles, and rents are usually determined by factors such as location, condition of the property. This is especially important when we look at rural areas. It is my view that tying the increase to medium earnings risks creating distorted assessments of the market and penalises landlords who let below the market value. I would hope that Maggie Chapman does not wish to increase regional inconsistencies and would seek to create a system that at very least reflects conditions not based on income. So I pose the question to Maggie Chapman, does she wish supply, particularly in rural areas, to further reduce, because of this amendment would exactly do that? With reference to Amendment 72 in the name of Maggie Chapman, describes a scenario where a tenant receives an increase of notice and they believe that that permitted rate, they must have notification to the landlord in writing in the views of 30 days rather than 21. Amendment 73 describes a situation where the tenant receives a rent increase. They can apply to the tribunal for determination of the previous rent increase, which took place less than 12 months ago. But they must first notify their landlord in writing of the reasons why they consider the rent increase to be unfair within 30 days of receipt of the increase notice rather than 21. My question is, how did the member arrive at 21 days as opposed to 30? What discussion took place between stakeholders, both in private rented sector and tenant rights groups, to ensure that this was proportionate and reasonable? And Amendments 34, 35 and 36, in the name of Maggie Chapman, introduces an increased penalty to landlords without property risks, driving good landlords out of the sector. The cumulative burden of regulations and financial risks can be continued when the sector, leading to property sales and a reduction in available rented homes. The impact is felt most acutely by tenants as the housing option shrinks and competition for remaining properties increase. Rather than focusing on penal measures, reductions in RETA determined will ensure that enforcement support for compliance, ensuring standards are upheld without undermining supply. Thank you, Presiding Officer.
Thank you, Mr Stewart. And I call on the Cabinet Secretary to wind up.
Thank you, Presiding Officer. I'm conscious that it's taking me some time to get through my initial remarks, so I'm keeping my closing brief. I did neglect to mention Edward Mountain's amendments 173 and 174. I'm very sorry for that, about that to him. The bill currently sets out that that where a rent control is in place, rent increases would be limited to one increase in 12 months, even if the tenant changes, and Mr Mountain's amendments, as he said, would reduce this to 6 months. I'm afraid to disappoint him, I can't agree to this. I don't support rent increases between tenancies, nor a shortening of these important periods. But in conclusion, Presiding Officer, I'd urge members to support my amendments. I'm pleased to support Maggie Chapman on 72 and 73 and Edward Mountain on 175, but ask members to reject the others.
Thank you, Cabinet Secretary. The question is that Amendment 152 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 153 in the name of Maggie Chapman, already debated with Amendment 138. Maggie Chapman, to move or not move?
Moved.
Moved. The question is that Amendment 153 be agreed to. Are we all agreed? No. Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Gordon MacDonald.
My phone wouldn't connect and I would have voted no.
Thank you, Mr MacDonald. Your vote will be recorded. Thank you. The result of the vote on amendment number 153 in the name of Maggie Chapman is yes, 8, no, 98. There were no abstentions. The amendment is therefore not agreed. I call amendment 154 in the name of Maggie Chapman, already debated with amendment 138. I remind members that if amendment 154 is agreed to, I cannot call amendment 66 by way of preemption. Maggie Chapman, to move or not move?
Not moved.
Not moved. I therefore now call Amendment 66 in the name of the Cabinet Secretary, already debated with Amendment 138. Cabinet Secretary, to move formally.
Moved.
Thank you. The question is that Amendment 66 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Gordon MacDonald.
Phone still wouldn't connect and I would have voted yes.
Thank you, Mr MacDonald. Your vote will be recorded. Point of order, Katie Clark.
Yes.
Thank you, Ms Clark. Your vote will be recorded. Thank you. The result of the vote on amendment number 66 in the name of Mary McCallan is yes 98, no 7. There were no abstentions. The amendment is therefore agreed. I call amendment 155 in the name of the Cabinet Secretary, already debated with amendment 152. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that amendment 155 be agreed to. Are we all agreed?
Yes.
The Parliament is agreed. I call amendment 156 in the name of Maggie Chapman, already debated with amendment 138. Maggie Chapman to move or not move?
Not moved.
Not moved. I now call amendment 157 in the name of Maggie Chapman, already debated with amendment 138. I remind members that if amendment 157 is agreed to, I cannot call amendment 67, 68, 69, 158, 159, 160, 161, 278, 279 and 162 by way of preemption. Maggie Chapman to move or not move?
Not moved.
Not moved. I now call amendments 67, 68 and 69, all in the name of the Cabinet Secretary and all previously debated with amendment 138. I invite the Cabinet Secretary to move amendments 67 to 69 en bloc.
Moved en bloc.
Does any member object to a single question being put on amendments 67 to 69? No member objects. Therefore, the question is that amendments 67 to 69 are agreed to. Are we all agreed? Yes. Are we all agreed? No. There will be a division and members should cast their vote now. I did think I did hear it that time, but why don't some of the other members exercise their vocal cords? You know what I mean? Just a thought. Here we go. So. The vote is now closed. Thank you. The result of the vote on amendments number 67 to 69 in the name of Mary McCallan is yes 99, no 8. There was one abstention and the amendments are therefore agreed. I now call amendment 158 in the name of Graham Simpson, already debated with amendment 138. Graham Simpson to move or not move?
Moved.
Moved. The question is that amendment 158 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Shona Robertson.
Connect. I would have voted no.
Thank you, Ms Robertson. Your vote will be recorded. Thank you. The result of the vote on amendment number 158 in the name of Graham Simpson is yes 41, no 67. There were no abstentions. The amendment is therefore not agreed. I call amendment 159 in the name of Graham Simpson, already debated with amendment 138. Graham Simpson to move or not move?
Not moved.
Not moved. I now call amendment 160 in the name of Graham Simpson, already debated with amendment 138. Graham Simpson to move or not move?
Moved.
Moved. The question is that amendment 160 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division. A member should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 160 in the name of Graham Simpson is yes 41, no 67. There were no abstentions. The amendment is therefore not agreed. I call amendment 161 in the name of Edward Mountain, already debated with amendment 138. Edward Mountain to move or not move?
Moved, Presiding Officer.
Moved. The question is that amendment 161 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Colin Beattie.
Presiding Officer, I couldn't contact. I would have voted no.
Thank you, Mr. Beattie. Your vote will be recorded. The result of the vote on amendment number 161 in the name of Edward Mountain is yes 41, no 67. There were no abstentions. The amendment is therefore not agreed. I call amendment 278 in the name of Megan Gallagher, already debated with amendment 138. Megan Gallagher to move or not move?
Not moved.
Not moved. I call amendment 279 in the name of Megan Gallagher, already debated with amendment 138. Megan Gallagher to move or not move?
Not moved.
Not moved. I call amendment 162 in the name of Edward Mountain, already debated with amendment 138. Edward Mountain to move or not move?
Moved.
Moved. The question is that amendment 162 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 162 in the name of Edward Mountain is yes, 42, no, 66. There were no abstentions. The amendment is therefore not agreed. I call amendment 163 in the name of Maggie Chapman, already debated with amendment 138. Maggie Chapman, to move or not move?
Not moved.
Not moved. I call amendment 164 in the name of Maggie Chapman, already debated with amendment 138. I remind members that if amendment 164 is agreed to, I cannot call amendment 70 by way of preemption. Maggie Chapman, to move or not move?
Not moved.
Not moved. I now call amendment 70 in the name of the Cabinet Secretary, already debated with amendment 138. Cabinet Secretary, to move formally.
Moved.
Thank you. The question is that amendment 70 be agreed to. Are we all agreed? Yes. Are we all agreed? Yes. The Parliament is agreed. I call amendment 165 in the name of Maggie Chapman, already debated with amendment 152. I remind members that if amendment 165 is agreed to, I cannot call amendment 166 by way of preemption. Maggie Chapman, to move or not move?
Moved.
Moved. The question is that amendment 165 be agreed to. Are we all agreed? No. Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 165 in the name of Maggie Chapman is yes, 8, no, 100. There were no abstentions. The amendment is therefore not agreed. I call amendment 166 in the name of Edward Mountain, already debated with amendment 152. Edward Mountain, to move or not move?
Not moved.
Not moved. I call amendment 167 in the name of Maggie Chapman, already debated with amendment 152. Maggie Chapman, to move or not move?
Moved.
Moved. The question is that amendment 167 be agreed to. Are we all agreed? No. Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Colin Beattie.
It's a bit dodgy here. I'm just wondering whether my vote was actually registered or not.
I can confirm, Mr Beattie, that your vote has been recorded.
Thank you.
Thank you. The result of the vote on amendment number 167 in the name of Maggie Chapman is yes, 8, no, 100. There were no abstentions. The amendment is therefore not agreed. I call amendment 168 in the name of Maggie Chapman, already debated with amendment 152. Maggie Chapman, to move or not move?
Not moved.
Not moved. I call amendments 169, 170 and 171, all in the name of Maggie Chapman and all previously debated with amendment 152. I invite Maggie Chapman to move amendments 169 to 171 en bloc.
Moved en bloc.
Thank you. I would ask whether any member objects to a single question being put on amendments 169 to 171. No member objects. The question is therefore that amendments 169 to 171 are agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendments number 169 to 171 in the name of Maggie Chapman is yes 8, no 100. There were no abstentions. The amendments, therefore, are not agreed. I call Amendment 172 in the name of Maggie Chapman, already debated with Amendment 138. Maggie Chapman to move or not move?
Not moved.
Not moved. I call Amendment 280 in the name of Mark Griffin, already debated with Amendment 152. Mark Griffin to move or not move?
Not moved.
Not moved. I call Amendment 173 in the name of Edward Mountain, already debated with Amendment 152. Edward Mountain to move or not move?
Moved.
Moved. The question is that Amendment 173 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 173 in the name of Edward Mountain is yes 24, no 83. There were no abstentions. The amendment is therefore not agreed. And I call amendment 174 in the name of Edward Mountain, already debated with amendment 152. Edward Mountain to move or not move?
Not moved, Presiding
Not moved. Before we turn to the next group, I would say to members that they will probably note that we have indeed passed the agreed time limit for the debate on Group 6 to finish, and therefore I exercise my power under Rule 9.8.4a, open brackets, small c, close brackets, to allow debate on the group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. We now move on to Group 7 on repairs and standards. I call Amendment 3 in the name of Maggie Chapman, grouped with amendments as shown in the groupings, and I call on Maggie Chapman to move Amendment 3 and to speak to all amendments in the group. Thank you.
Thank you, Presiding Officer, and I move Amendment 3 in my name. Amendments 71, 71A, 78 and 78A set an important principle that rent should not be increased if minimum standards are not met. Many landlords in the private rented sector provide high-quality homes, but some do not, and improvement is required. At 55% of homes in the private sector have wall insulation. This compares to 69% in the social sector. That's why almost 70% of social homes have an EPC rating of C or higher, almost 20% higher than the private rented sector. Levels of disrepair to critical elements such as heating, water supply and others are the highest in the private sector than any other. And in terms of overall quality, in 2023, 40% of private sector dwellings failed the Scottish Housing Quality Standard, compared to 30% in the social sector. And the private sector has about twice the proportion of properties failing in 3 or more criteria compared to social housing. There's a clear problem with poor energy efficiency, damp and other problems in some parts of the private rented sector. And if we freeze rents where minimum standards are not met, landlords will have little choice but to bring their properties up to scratch. I have listened to concerns expressed previously, and 71A and 78A make it clear that I'm not intending to bring in new standards, and existing tolerable and repairing standards can be used. To do some further tidying up, I'd like to note that Amendments 3 and 5 are older versions of 71 and 78 respectively, so I won't press 3 and 5 when we get to them. Moving to other amendments, I welcome Mark Griffin's group of amendments on damp and mould. Better defining mould and damp and ensuring inspectors are properly qualified to detect it are both good steps towards better tackling poor quality accommodation. I also support his Amendment 299 to modify the repairing standard with a view to speeding up how quickly repairs are done. Paul Sweeney's Amendment 115 to allow tenants to refer a property to the local authority for it to consider purchasing and improving is welcome too. With so relatively few inspections done, an issue which my colleague Lorna Slater will speak to on behalf of Ariane Burgess, councils will not necessarily be aware where the poor quality properties are, and Mr Sweeney's Amendment 115 addresses that. Having just launched an £80 million scheme for councils to buy properties and get people out of temporary accommodation, this does appear to be in line with the Scottish Government's approach. Before closing, I'd like to address Jamie Halker-Johnson's Amendment 244, which would require a presumption in favour of enabling direct emission heating systems in rural areas and island areas. While I appreciate the challenges faced by rural and island communities, green technologies are improving all the time, and with time running out to tackle the climate crisis, we cannot encourage the installation of polluting heating systems in perpetuity. We need to change how we do this. Yes.
Jamie Halker-Johnson, briefly.
Thank you. I'm very grateful to the member for taking intervention. I mean, I do respect that there are improvements in some of the heating systems, but does she not accept that for many communities, many homes across the Highlands and Islands, particularly our region, actually that secondary direct emission system is a real lifesaver when bad weather hits?
Maggie Chapman.
I thank Jamie Halker-Johnson for his intervention, and yes, I do. As somebody who represents the North East, I too am familiar with the consequences of bad weather. But I think we need to be future-proofing our legislation, and I think there are mechanisms that we can use in the short term that don't require primary legislation. And it's putting this provision in the bill that I think is problematic. So, Presiding Officer, all in all, I think that they're really important principles in many of the amendments in this group. Accommodation needs to meet standards, and we should be doing whatever we can to drive up those standards. My amendments in this group do that. Thank you.
Thank you. I call Graham Simpson to speak to Amendment 228 and other amendments in the group. Mr Simpson.
Thank you very much. Can I start with Amendment 228? The idea behind this was that we can keep a record of a property, a kind of lifetime record of the work that's been done to a property. But, however, on reflection, I think the way the amendment is worded is perhaps too onerous, so I'll not be pressing that. So I'm just going to move quickly on to Amendments 230 and 231, which deal with damp and mould. There's been a lot of debate, certainly at stage 2, about AWAB's law, and I'm very grateful that the Cabinet Secretary has said she wants to bring in AWAB's law into Scotland. So these amendments would actually do that, but in a tougher way than that which applies in England. Now, that's not necessarily a bad thing. I did attempt to lay a manuscript amendment to mirror what will be the situation in England when the UK government lays regulations Sadly, it was rejected, and I think that's a missed opportunity. It would have been good for Parliament to have the chance to vote on that. Mark Griffin, in his amendments, tackles the same area, really, and he has my support. I hope he presses his amendments. Now, if I could just move on to Paul Sweeney's Amendment 115, that would establish a system where if someone was in a substandard property, they could ask their council to buy it and then transfer it to a housing association. I'm not really clear on what the cost of all that would be, or whether councils or housing associations would even want such properties. I suspect they wouldn't, but I'll certainly take the intervention.
Paul Sweeney, briefly.
I welcome Mr Simpson giving way. Just if I can perhaps provide some clarity on that point that he makes. This activity already is undertaken, certainly in the City of Glasgow. My idea is that it gives a greater system for tenants to express a desire for their property to be considered for such a scheme, and it perhaps creates a better demand signal or understanding of substandard property that might be eligible for CPO activity that is already undertaken, certainly in Glasgow. And other local authorities don't have such a scheme, but certainly in Glasgow the need is significant. It might also be worth consideration that there could be a scheme to offset the cost of dilapidations or making good dilapidations against the value of the property. There's certainly provisions for that in legislation in relation to listed buildings, though unfortunately it's only actually been exercised on one occasion in Dundee in the 25 years plus that legislation has been enforced. So there are behavioural issues with local authorities, but I think it's worth testing this and trying to put it on the statute book, because it would be a useful mechanism.
Well, that was quite an intervention. We probably don't need to hear from Mr Sweeney again, because he's explained it all. So I will study the wording of the amendment. I feel it's too onerous, but Mr Sweeney wants to add to what he's already said. I'll look forward to hearing that, and I'll end it there. Thank you.
Thank you. I call Mark Griffin to speak to Amendment 294 and other amendments in the group. Mr Griffin.
Thank you, Presiding Officer. I welcome the Scottish Government's commitment to full implementation of AWAB's law for both private and social landlords. This will help some of my constituents who are currently trying to ensure that their homes are not putting the lives of their children in danger because of damp and mould. I think, however, we can go further to ensure that people have confidence that issues of damp and mould are identified correctly and acted upon quickly. My amendments are designed to strengthen the Government's commitment by tightening up conditional language and ensuring robust enforceable standards for tackling damp and mould in Scotland's homes. Similar to other amendments in this group, I have sought to tighten timescales around dealing with damp and mould where it's found in homes. I've stipulated that ministers must publish statutory guidance approved by Parliament by affirmative procedure on the timescale for landlords to respond to a resident's complaint of damp or mould, and then the timescale for effectively dealing with damp or mould once it's found. I believe that clear, enforceable timescales are essential to protect tenants' health and well-being, and linking this to statutory guidance, subject to parliamentary approval, ensures accountability and transparency of that process. Voting in favour today would close any loopholes in the current wording and guarantees that action is not left to landlord discretion. The next in the package of amendments requires ministers to publish statutory guidance, again approved by Parliament, defining what constitutes a significant level of damp and mould, which would trigger the legal requirement for landlords to act. The current wording is that as long as a property is substantially free from damp and mould, then it meets the tolerable standard. Now, one person substantially free from can vary wildly from another's, and so I think this amendment can give tenants and landlords clarity on when action is required. I accept that there is current guidance on the levels of damp and mould in homes, but this allows ministers to ensure that the law is robust and tenants are not left in unsafe or unhealthy conditions due to those perceived vague thresholds. I've also stipulated that ministers must publish statutory guidance, again approved by Parliament, setting out the required level of qualification for inspectors who determine the presence and severity of damp and mould. Now, that would ensure that inspections are carried out by competent, qualified professionals and protects tenants from inadequate or inconsistent assessments. We've heard over and over from tenants, I'm sure many MSPs will have had them at their surgeries, of those who come to assess damp or mould in their homes. They're told to spray it with disinfectant, open a window, cover it up with damp-proof paint, and all of a sudden that's going to fix real substantive structural issues related with dampness. And I think the qualification level of inspectors would go some way to give residents the reassurance they need that their complaints about damp and mould are being treated appropriately. I think these group of amendments come as a package. They are practical steps to ensure that AWAB's law is implemented in full with clear standards and robust protections for tenants. They'll help deliver safe, healthy homes for everyone in Scotland and ensure that our legislation is both effective and enforceable, helping my constituents and tenants throughout Scotland have confidence in the laws designed to protect them and their children from ill health, simply of the homes that they happen to live in. Thank you, Presiding Officer.
Thank you. I now call Lorna Slater to speak to Amendment 300 and other amendments in the group. Ms Slater.
Thank you, Presiding Officer. I'm speaking to Ariane Burgess's amendments as she's currently unable to attend the Chamber. Amendments 300 and 301 revamp the rules around local authority inspections of private rented accommodation. Amendment 300 allows local authorities to routinely inspect homes. Amendment 301 gives them the power to undertake spot checks of private lets at any time, so long as they have the prior consent of the tenant. Both amendments build on existing powers, will support tenants and will push standards higher by cracking down on the minority of rogue landlords who do not meet their obligations to provide good quality housing. That's something we want to underline here. Many private landlords are good landlords. They do their best to meet their tenants' needs and fulfil their obligations to them. These landlords are let down by a minority, and it is this minority whose behaviour and practice that we're trying to change. It's pleasing to note that these amendments have support from stakeholders representing both landlords and tenants, including Scottish Lands and Estates and Living Rent. We believe that this is a reflection of the fact that we've listened to and acted upon the feedback on these amendments received at Stage 2. Namely, there was a concern that imposing a £10,000 fine on landlords would deter investment in the private rented sector. We have taken this on board and modified the amendment so that ministers will have the powers to determine the level of fine private rented landlords may face. Likewise, we have also stated that ministers must set out a timescale that private landlords have to resolve issues within before they face a fine. Ministers will also be able to determine the standards landlords will be held to by local authorities. These changes maintain the spirit of Ariane's Stage 2 amendments along these lines. Namely, they put rogue landlords on notice that it's not okay to provide dangerous substandard housing. And if they persist in not fixing problems with the homes they rent, they will face a penalty. Amendments to 380 and 381 are consequential to 300 and 301. I also wish to add that the Scottish Greens welcome Richard Leonard's move to bring back the Seasonal Worker Accommodation Standards Amendment that we brought at Stage 2. We believe Amendments 348 to 350 in his name would provide an often exploited group with valuable protections and rectify a glaring gap in accommodation standards that the Scottish Government has thus far been slow to act on.
Thank you. I now call on Richard Leonard to speak to Amendment 348 and other amendments in the group. Mr Leonard.
Thank you, Presiding Officer. These three amendments are three different means, but each to the same end: to close the current legal loophole which allows for the exploitation of seasonal migrant workers on farms across Scotland, and so to end the national scandal of these farm workers who have no protection whatsoever, none, over the standard of their accommodation. There are 6,000 to 7,000 migrant workers on 6-month-long seasonal visas in Scotland, mostly coming from Central Asia. 95% of them are tied in accommodation with their employer. And that accommodation, in almost all cases, caravans, porta cabins, even containers, windowless metal boxes, are all exempt from regulation, are exempt from standards and exempt from inspections. There's no national law, no local bylaw, no national inspection, no local inspection. Now, I've met these workers a number of times over the last year and a half to hear their experiences at first hand. And when I met them again just a few weeks ago, they told me that as long as this Parliament fails to legislate, fails to act, fails to enforce, and even with an expose on national television by ITN, nothing has changed, except that their rent, that's changed. It's gone up again this year from £70 a week to £74 a week. That's £11,000 per caravan per season, and they're on £12.21 an hour. So I have to ask, as I've asked in Parliament before, where does all that money go? Where does all that rental income go? Because it is not reinvested in improving the standard of accommodation. So when the President of the National Farmers Union in Scotland tells us at the weekend, I quote, "Profitability must be front and centre if we are serious about sustainable farming," then he needs to reflect on this. When I met those workers just last month, they showed me photographs, played video evidence and gave me personal testimony of caravans in the middle of fields, dangerously perched on bricks, with gaps in the walls and ceilings so wide that the workers freeze at night, of dampness and mould, of containers with no windows or ventilation, of caravans with windows that won't close, of overcrowding, with caravans designed for 4, commonly sleeping 6. And poignantly, they spoke of the safety risks that they face, including the risk of fire. But let me also put on the record that I am talking here about the living conditions of both men and women workers. And I can't help feeling that because much of this accommodation is out of sight, and because these are migrant workers who feel unable to speak out publicly for fear of being blacklisted, that they have been abandoned and expected to survive not just in squalor, but in slave-like conditions. Following amendments which I tabled to the Agriculture and Rural Communities Bill last year, and thanks to agitation inside and outside Parliament by the highly effective Worker Support Centre, which is an outstanding advocate for these workers, the Government set up a working group which has been carrying out a scoping exercise, looking at what can be done. And I raised this in questions in Parliament back in May to the then Housing Minister as a call to action. But I repeat, nothing has changed. The First Minister told ITN over a year ago that he found the pictures he was shown by the journalist Peter Smith, I quote, "completely unacceptable and troubling," and that he would take a personal interest. But I repeat, 1 year later, nothing has changed. So I say to the First Minister today, 3 out of the 6 biggest areas of employment of seasonal migrant labourers are in Scotland, in Angus, in Fife and in Perth and Kinross. This is rightly troubling for the First Minister. It should be rightly troubling for all of us. But there is no one more troubled than those workers sleeping out in those fields tonight. Amendment 348 requires inspectors in the Agricultural Wages Board to ensure that this seasonal workers' accommodation is fit for human habitation. It's similar to an amendment I tabled last year in the Agriculture and Rural Communities Act. And at stage 2 of this bill, Ariane Burgess also laid a similar amendment but did not move it. The Cabinet Secretary said in response at stage 2, I quote, "I absolutely recognise the point that you are making, and I would be happy to provide that information in writing to you and the committee following today's discussions." But when a note was sent to the committee after the Cabinet Secretary's appearance before it, as far as I can see, nothing was included which addressed this. My view is that the Agricultural Wages Board, which enforces the accommodation rate on these seasonal workers, should also be the board that enforces the accommodation standards for these seasonal workers. 21 Scottish Government employees currently carry out inspections as part of their work, and they work in the Rural Payments and Inspections Division. So, that's the division which pays out £660 million a year in farm payments on our behalf. So I would argue that gives them, and it gives us, some leverage. Amendment 349 is another way of breaking the impasse and closing the exemptions and loopholes in the current legal framework. Under the Housing Scotland Act 1987, local authorities have a duty to ensure that houses meet a tolerable standard, or if they do not, to close or demolish them. The tolerable standard applies to every house in a local authority area, but it does not apply to this accommodation. Under the 1987 Act, mobile homes are not considered houses, so they fall out with the scope of a tolerable standard. And that's what we need to address. There are provisions through bylaws, so I sent a Freedom of Information request to every local authority in Scotland last year, and not one of the 27 which responded had any such bylaw. This amendment would seek to bring them within scope. And finally, Amendment 350 is yet another route to simply end the exemption of seasonal workers' accommodation from the provisions of the law, in this case the Caravan Sites and Control of Development Act 1960. Yes, I'll take an intervention.
Briefly, Graham Simpson.
Yes, I will be brief. Richard Leonard has outlined a quite disgraceful situation that people in this country are having to live in such substandard conditions. Nobody should have to do that. So my question for Richard Leonard is it my understanding of what he's telling us is that there are no rules protecting these people? There seem to be no inspections of the accommodation or the standard of it. Is that his understanding too?
Richard Leonard.
Yes, it is. And I got a parliamentary answer back from Paul McLennan on the 12th of November 2024, in which he said caravans and static homes provided by employers through a service occupancy agreement are not subject to housing standards. Where agricultural land is used for the accommodation of people involved in farming operations on a seasonal basis, a site licence for a caravan is not required. So I'm asking for these loopholes to be closed. Because how can it possibly be justified? How can it possibly be right that if you stay in a caravan for a week's holiday, you are entitled to certain tolerable housing standards, but if you're working on the land for 6 months, helping to bring the harvest home, stocking our supermarket shelves, generating export earnings, you are not entitled to any housing standards whatsoever? So I move the amendments in my name.
Thank you, Mr Leonard. Just to advise the Chamber, we are, as you will be aware, well behind time in terms of this debate, so I'd encourage as much brevity as possible without failing to do justice to the seriousness of the issues. And I invite Jamie Halker-Johnson to speak to Amendment 244 and other amendments in the group. Mr Halker-Johnson.
Thank you, Deputy Presiding Officer. My amendments 244 and 259 are as I submitted at stage 2. Together they provide that when regulations are made by the Scottish Government relating to direct emission heating systems, they must implement a presumption in favour of secondary direct emission heating systems in homes in remote and rural areas and on our islands. They aim to ensure that in homes in areas where essential connections may be less reliable or subject to increased risk of being lost, often because of extreme weather, and that where help or support is less readily available, facilities to heat, cook and provide hot water are maintained. There have been plenty of examples recently where the extent of damage to energy distribution has caused major disruption to services to local homes, not only in my own region in the Highlands and Islands, but across the regions of many of the members in this chamber. Having experienced being snowed into my own home in Orkney for 5 days without power, but with access to heating and hot water provided by our wood-burning stove, and the ability to cook hot meals in a house, parts of which were registering temperatures below zero, I know all too well how important resilience and having the appropriate backup can be. Only last year, in response to proposed regulations in this area, I introduced a motion to Parliament which achieved cross-party support, including from several members on the SNP benches, about the importance of wood-burning stoves and other direct emission heating in rural and island communities. This was followed by an excellent members' debate where the topic was discussed in far more detail than we'd be able to fit in today, and where there was widespread support, again from across the parties, including the SNP, for the importance of direct emission heating in remote and rural communities. I'm pleased that the Scottish Government U-turned on their proposed ban on secondary emission heatings like wood-burning stoves in new-build homes then. However, despite that U-turn in November, it's become clear that secondary heating should be protected in primary legislation, with a requirement on the Scottish Government to take due regard of these issues into the future. At stage 2, the Cabinet Secretary for Social Justice questioned the necessity of these amendments, indicating that the Scottish Government had no plans to bring forward further regulation in this area at this time. Shirley Ann Somerville noted her concerns that my amendments could tie the hands of future governments, particularly where there remains scope for technological advancement. These amendments do attempt to tie the government, and if change is considered, require them to come back and consult in this Parliament. Had this amendment been law, then it may well have saved ministers time and not a little embarrassment last year when they did finally U-turn. Presiding Officer, it is important that remote and rural and island homes have access to viable and reliable secondary heating options. They're not luxury items in our homes. They're not something that looks nice in the corner of the room. They help keep people safe and warm and alive in the worst of conditions. It's vital that regulations made here in Edinburgh take into account the needs of those communities, our communities across the Highlands and Islands and other parts of rural Scotland, where help is further away and longer to arrive. I urge members to support my amendments 244 and 259, which I move.
Thank you. I now call on Paul Sweeney to speak to Amendment 115 and other amendments in the group. Mr Sweeney.
Thank you, Deputy Presiding Officer, and I rise to speak to Amendment 115 and the associated Amendment 117 in this grouping. As has been intimated by colleagues already across the chamber, the purpose of this amendment is to ensure that a property in private let, where it is deemed to be substandard by failing to meet either the repairing standard or the tolerable standard for a period of longer than 12 months, the tenant would have a right in statute to apply to the local authority to initiate action, in addition to the obligations on the local authority that already exist in statute, as was already discussed in several housing acts going back to the 1980s, in addition to the provisions that are already there, such as closing orders, demolition orders, maintenance orders or repairing maintenance orders. The local authority, in addition, could consider escalation to a compulsory purchase order for the property and therefore, after doing so, transfer it to an appropriate local registered social landlord, whether that be the local authority itself, in the case of local authorities that have council housing, or a third-party housing association, in the case of local authorities such as Glasgow, where direct local authority operation of social housing no longer takes place. So the government could underwrite that procedure and recover the costs of the purchase over a reasonable period, for example, 25 years, from the receiving social landlord taking ownership of the property, which would have the effect of making the policy effectively cost neutral for the government and be a much more sustainable investment strategy than, for example, having to fund emergency temporary accommodation on a haphazard ad hoc basis. It would allow for established best practice of using CPOs to take over long-term vacant housing stock to be expanded to housing stock that is generally in poor condition, although habitable, which already happens to be undertaken in Glasgow districts such as Govan Hill, and for this approach to be more systematic in nature and scaled up on a national basis and to learn those lessons and that best practice. There's already provision in legislation. I look, for example, to the 1997 Planning List of Buildings and Conservation Areas Act, where Section 45 of that Act allows for a direction for minimum compensation, so that where the local authority acquires the property, they can actually offset the costs of repair of the building against the value of the property, so that they're not actually incurring that cost and acquisition, they can offset it. So I think there is reasonable scope in this bill to do something useful here and to improve the mechanisms available to local authorities to bring dilapidated housing stock back up to a reasonable standard for habitation. As has been mentioned, Glasgow has been at the forefront of using compulsory purchase orders to tackle problems of long-term vacant properties, which has increased affordable housing supply and ensured the upkeep of pre-1919 tenement stock in particular, of which there is around 70,000 in the city, with an estimated repair backlog of £3 billion. The compulsory purchase order process has been a good way of responding to the blight that has been caused by derelict, abandoned flats and homes that have been left vacant for a variety of reasons, or properties that have previously been let out but are now below the tolerable standard. And with the government's recent announcement of an increase in the acquisitions fund from £40 million to £80 million, this would actually be a useful way of focusing that money into areas of priority need. Glasgow's promotion of compulsory purchase orders has sent a message that the local authority is active in taking steps against private landlords or other individuals who fail to address problems with their property, although it is seen as a last resort measure. 52 homes across Glasgow have been purchased or pursued for compulsory purchases since 2019, and 34 of those have been concluded with the acquisition of the property. In other cases, with the serving of the notice, 13 owners actually opted to sell voluntarily to housing associations, and a further 2 properties were sold or occupied by family members, which meant that the planned compulsory purchase order was not continued. But in all these cases to date in which these compulsory purchase orders have been confirmed, once Glasgow City Council has invested in the property, it is entered into back-to-back agreements with local community-based housing associations, which there are over 60 in Glasgow, which have carried out the necessary repair works with support with grant funding to bring the property up to a tolerable standard and back into active use in order to provide affordable housing for those who need it. And given the housing emergency in Glasgow and in other parts of Scotland, I think this need is particularly acute, and it would be a useful tool to bring in now. And I don't think we need to wait for the government's ongoing consultation on wider CPO, because the pace of change is needing something to get out ahead of it. And I think this could be a very useful mechanism for the government to implement now and test how it works and performs with the local authorities. Some of the properties that have been targeted previously for CPOs have been lying empty for more than 14 years, while other properties have been designated as being below the tolerable standard for more than 5 years. And all of these empty properties, because they are generally tenemental stock, create environmental blight and affect neighbours in the wider community and even in the same close. The benefit, therefore, that is derived from bringing these properties and other homes back into use is massive, particularly for tenants and owners who live in close proximity and have suffered because of abandonment or the poor quality of maintenance. Although there are budgetary constraints that limit how many CPOs a local authority can achieve, I think these steps are really useful. And they are, of course, complicated, time-consuming, costly and resource-intensive, but we can build a learning curve here. And in Glasgow's case, they are dependent on building this partnership with housing associations. So I think that the government should consider accepting this amendment and moving forward with this and testing how it could perform.
Thank you, Mr Sweeney. I now call Megan Gallagher to speak to Amendment 375 and other amendments in the group. Ms Gallagher.
Thank you, Presiding Officer, and I appreciate that I have probably been rather cheeky submitting this amendment, as I did so at stage 2, and I understand that it probably doesn't encompass the exact intent of what the Housing Bill aims to do. But I have had several discussions with previous ministers regarding the publication of the Grenfell Tower Inquiry, TGI Phase 2 report recommendations. In fact, I wrote to the previous minister, Paul McClellan, and I do thank him once again for the time and engagement that he gave to this issue whilst he was in post. Identifying buildings and remediation has been incredibly slow, and I'm still concerned that the method for testing fire performance, BS 8414, is still a route for buildings to fall within compliance. Buildings such as hospitals, care homes, boarding schools, hotels, I do believe that they are effectively dwellings, they're buildings, but people, of course, can stay in them. And for that reason, they do need to be captured within the ban for combustible facade material. I submitted Amendment 375 in order to continue raising these concerns and also the consultation with the Scottish Government to try and ascertain what their position is in relation to for the ban to include hotels, hostels, boarding schools and any other building that falls into that category. I don't know whether the Cabinet Secretary, of course, considering other amendments that we're discussing this evening, is in the position to do so today or tonight. However, if she's not able to, we would welcome the Cabinet Secretary perhaps coming to committee, or when she's able to provide a statement, an update on where we are in relation to remediation of these particular types of buildings, and particularly what report recommendations the Government can give an update on in terms of where we are. I do believe, it was quite some time ago, but I do believe that Graham Simpson is not going to press his amendments on this section. Is that right? Sorry, I've caught him off guard. It's just in relation to the amendments. I understand what Graham Simpson is attempting to do, because he has, of course, carried out a lot of work in relation to damp and mould properties. However, I do believe... yes, I will.
Graham Simpson, briefly.
I will attempt to answer Ms Gallagher's question. So, my Amendment 228, I will not press. Amendments 230 and 231, which relate to AWAB's law, I will probably not press those either. So I hope that helps.
Megan Gallagher.
Helpful clarification. The reason I was asking that is because I do believe that 14 days is not always practicable for landlords to be able to carry out repairs. If you think about seasonal holidays, weather conditions, rurality in terms of properties, I think this amendment, if it was brought in too broadly, could impact the ability for landlords to actually carry out the repairs within that time frame. However, I do understand and agree that they must carry out the repairs within a reasonable time as soon as possible. And I understand that we will be soon voting on amendments that relate to damp and mould issues, which I hope will improve building standards for so many people within the private and social rented sector. If I can touch upon amendments 300 and 301 in the name of Ariane Burgess, I am concerned that no permissions will be sought from the landlord directly, especially as they own the property. And there are other processes that deal with concerns that tenants raise with rental properties, and I don't believe that it is appropriate for local authorities to effectively have more authority over landlords in respect of maintenance, safety and quality. Again, this amendment, although I don't believe it's intended, I think it can continue with that rhetoric that I mentioned earlier on regarding the demonisation of landlords, the vast majority of whom, and I welcome Ariane Burgess's tone because it's different from the tone that we've heard from other members this evening, who maintain their properties to the highest of standards. So for that reason, we won't be supporting the amendments in Ariane Burgess's name this evening. Thank you.
Thank you. Members will be aware that despite extending the previous time limit by 30 minutes, we will shortly be reaching the next time limit. We already have 2 more groups to debate. As a consequence, I'm minded to accept a motion without notice to propose that the last sentence of Rule 9.8.5a be suspended. I invite the Minister for Parliamentary Business to move such a motion.
Officer.
Thank you. The question is that the last sentence of Rule 9.8.5a be suspended. Are we all agreed? Yes. That is agreed under Rule 9.8.5a. I'm minded to accept another motion without notice to extend the debate by 30 minutes on amendments. I ask the Minister for Parliamentary Business.
Move, Presiding Officer.
Thank you very much indeed. The question is that the debate on amendments be extended by 30 minutes. Are we all agreed? That is agreed. And I call on the Cabinet Secretary, please.
Thank you, Presiding Officer. The overall condition of housing in Scotland has been steadily improving over the years, and this has been driven principally by the tolerable standard, the Scottish Housing Quality Standard and the repairing standard. And whilst I recognise that there is more to do, my starting point is about strengthening the existing powers and strengthening the existing standards. Now, I have already confirmed, but I reiterate today my intention to bring forward AWAB's law across the rented sector in Scotland from March 2026, starting with damp and mould. The Scottish Government is currently hosting a series of roundtables over the course of this month to better understand the timescales for investigating and commencing repairs and their potential impact on tenants and landlords. Firstly, I want to turn to amendments in the name of Maggie Chapman. Amendment 3 would provide that rents in rent control areas not be increased unless the property meets minimum standards. Amendments 71 and 71A are alternate amendments to Amendment 3, which would also provide that standards may relate to repair and safety. Under these amendments, the regulations must specify the method by which the landlord can demonstrate compliance with the standard and the complaints procedure where tenants can challenge the landlord's compliance. The amendments also expand on what can be covered in the regulations by noting the minimum standards may be defined with reference to the statutory tolerable and repairing standard. Amendments 5, 28, 78 and 78A would replicate these, but for non-rent control areas. Now, whilst I agree on the importance of all rented properties complying with appropriate standards, there are already a suite of statutory standards and enforcement measures in place for rented properties, that tripartite that I mentioned before. I must re-emphasise that adding a further housing standard would create considerable confusion for landlords, for tenants and for local authorities as to which standards the landlord must comply with. So there are already there are already existing standards, and accompanying that are broad powers to amend these existing standards where we need to. And so I can't support these amendments. Turning to those in the name of Mark Griffin, Amendment 294 seeks to add the enabling power in the 2001 Act, adding to the non-exhaustive list of matters about which ministers may make provision to include the qualifications required by an inspector to undertake an inspection relating to damp and mould in a house. Now, whilst I understand why Mr Griffin is seeking to impose this, it's in the Government's view, it's highly unlikely that any registered social landlord or local authority would use unskilled workers in any event, including for repairs and inspections. Social landlords are likely to have contracts with suitable, appropriately qualified tradespeople, and we therefore would see this as unnecessary. But I think, perhaps most importantly, there's a risk that making such regulation could potentially reduce the number of tradespeople who will be available to undertake remedial work, and therefore could extend the time required to complete repairs. And I think this would run contrary to the intentions of Timaeus repairs that underpins AWAB's law, something that I think I know Mark Griffin is supportive of. Amendment 295 relates to statutory guidance that Scottish ministers have the power to issue in connection with the tolerable standard, which is set out in the 1987 Act. The amendment makes clear that such guidance may further specify the circumstances in which a house can be considered to be, quote, substantially free from rising or penetrating damp. Now, ministers already have the power to issue guidance on such matters, and we were already planning to do so in connection with the implementation of AWAB's law. This will be done as part of our targeted engagement, and therefore I am very much in agreement with Mark Griffin, and I am happy to accept this amendment. In 296 and 297, however, Mr Griffin is seeking to amplify any guidance that is issued on damp by Scottish ministers in both the private and social rented sectors. And whilst I support the reason behind this, they are unnecessary additions to the statute book when ministers have extant powers to issue and vary or revoke guidance. Both social and private landlords already have a statutory duty to have regard to guidance in connection to the tolerable standard and the repairing standard. And as I've explained, the Government has committed to implement AWAB's law, and part of that process will involve provision of guidance. And whilst that renders the amendments unnecessary, I'll ensure that members are very closely engaged with that work. Amendment 299 amends the regulation power in connection with the repairing standard in the private rented sector. This would put on the face of the bill that certain factors that ministers may make provision in connection with, including the period within which a landlord is to respond to a notification from a tenant and the commencement and completion of that work. An amendment to the enabling power is not necessary to implement AWAB's law in the private rented sector, which I've already committed to doing. Whilst I appreciate the rationale behind this amendment, I wish to offer further reassurance that existing plans are underway to implement AWAB's law, and we can do that using existing powers which are broad in terms of their scope and, importantly, are appropriate. Amendment 230 in the name of Graham Simpson would amend the repairing standard in the private rented sector and require private landlords to complete work within a period of 14 days rather than within a reasonable period. This would have very far-reaching consequences for landlords, including in connection with their property rights. There's a number of factors which, as I think have already been alluded to, may prevent work being completed within 14 days, such as sourcing appropriately skilled professional tradespeople and access to the property, or the scale of the works themselves. I'll just finish this point and then I'll very happily take an intervention. Creating a system whereby this is the inevitable outcome would be problematic and must be opposed. And I suppose just to conclude, AWAB's law seeks to introduce timescales for the investigation and the commencement of works, as opposed to timescales for the completion of works, which clearly, depending on the scale of the work involved, could necessarily take more than 14 days. I'll take the intervention.
Briefly, Graham Simpson.
I thank the Cabinet Secretary for taking the intervention. I've already accepted the point. She didn't really need to labour it. I accept the point about my amendments. Can she tell us how she plans to introduce AWAB's law? Is she going to be using regulations or some other means?
Cabinet Secretary.
Yes, I'm quite sure that this has already been spelled out, but the powers that we need to do it in the social rented sector, I understand we're taking at stage 2, and the powers to implement it in the private rented sector are already in existence. And I was just trying to give members the courtesy of responding to each of their amendments, but I will skip through Mr Simpson's remaining in case he thinks I am labouring the point. I'm also, moving to Mr Sweeney's amendments on purchase of poor quality housing. This brings back Amendment 115 after not pressing it at stage 2, and Amendment 117 seeks to ensure that the regulations are subject to affirmative procedure. Now, I wrote to Mr Sweeney on the 21st of July outlining the reasons why the government's position hasn't changed from stage 2. He's broadly explained it, but from our perspective, the amendment would oblige the ministers to provide a process by which a tenant may request a local authority to buy the house that they rent, where that house does not comply with housing standards. And although I absolutely support the principle behind this, namely that private rented homes should be of a good quality, the amendments as proposed could lead to the local authority purchasing a suite of substandard properties rather than what we should do, which is enforcing housing standards, as is currently the case. Now, there's no need for a statutory right for a tenant to request that a local authority exercise powers of compulsory purchase. As Mr Sweeney has pointed out, councils already have that power. Tenants can already approach their local authority to make such a request. But where a landlord has failed to comply with housing standards, I continue to believe that it would be more appropriate for those standards to be enforced rather than to expect the local authority to purchase the property and moving away from that ad hoc approach that's currently taken. Yes, I will.
Briefly, Paul Sweeney.
Thank the Minister for giving way. It is unfortunate because the Cabinet Secretary for Social Justice, who was leading the amendments at stage 2, did offer to work with me to agree something at stage 3, but that conversation never actually took place, unfortunately. So it seems like we aren't able to reach that compromise because the discussion wasn't facilitated. So really what I'm trying to say is that this is not about knocking out existing provisions. I think there is a sliding scale of intervention that a local authority should be able to have, including maintenance orders and obligations on landlords. But if that is irreconcilable, then the ultimate option would be to move towards a compulsory purchase, which is already in practice in Glasgow. My idea is, how do we formalise that and how do we move it beyond Glasgow to other local authorities that don't do it? And I think this could be a mechanism of doing it. But interesting to see if the Cabinet Secretary has other proposals.
Thank you, Presiding Officer, and thanks for the intervention. I suppose my view is that it's not appropriate to formalise it, because what's appropriate is for substandard housing to be brought up to standard and for there to be the option, as Glasgow City Council are clearly utilising, to use compulsory purchase and to do exactly as the member has described. And I would highlight to him that on the 19th of September we launched a substantial consultation on compulsory purchase reform, which includes provision on sale and lease orders as well, and I would encourage him to engage with that. It's open until the 19th of December. Moving as swiftly as I can, Presiding Officer, to heating systems, Amendments 244 and 259 from Jamie Halcrow-Johnson are identical to amendments brought at stage 2 and seek to restrict policy making in any future attempt to regulate heating systems. As outlined previously, the Government's approach already protects the use of direct emissions in secondary heating, if required, for exactly the circumstances referred to, including in rural properties. And I would point to the new build heat standard. I'll just make a little bit more progress. The new build heat standard already allows for secondary heating systems of the kind specified in the amendment. And I would just point out to members that with this, you're not voting against, if you're voting against this amendment, it's not a vote against wood-burning stoves or other secondary heating systems, as the amendment is not needed to protect their use. That's it's simply unnecessary. I think I should probably make progress, Presiding Officer, but I can allow a brief intervention, but it needs to be brief. Jamie Halcrow-Johnson.
I thank the Cabinet Secretary for taking intervention. The problem with some of the regulations at the moment is that they put such requirements on secondary heating that they're almost impossible, both from a financial or a technological point of view, to put in place, such as they have to be turned off the minute power comes back on. Now, if you're losing power constantly back and forward, that means a lot of these systems simply aren't work. So you essentially ban them, but by a secondary way.
Cabinet Secretary.
I take on board the points that have been put to me, but I suppose my concern in respect of the deliberation of primary legislation is that the ability to have them is there, and the Government, as Mr Halcrow-Johnson pointed out, made provision for that in respect of the new build heat standard rather recently. Amendments 300 and 301 are alternative amendments which would create a power for local authorities to inspect a house which is entered in the Landlord Register, and impose a fine to be set by Scottish ministers on the landlord if the house doesn't comply with relevant safety, quality and energy efficiency standards. These provisions are not required. There are existing enforcement mechanisms for the repairing standard under the 2006 Act and the tolerable standard under the 1987 Act. And the First Tier Tribunal can already impose a repairing standard enforcement order under the 2006 Act if a property fails the repairing standard. A local authority can issue a work notice under Section 30 of the 2006 Act if a property is considered to be substandard. And this would include properties which fail the tolerable standard. So in light of that, I would ask Ms Burgess not to press these amendments, as there are a suite of existing measures which deal with these issues, and I do fear that creating further legislative requirements is going to create a very confusing regulatory landscape. Coming to Mr Leonard's contribution on seasonal workers, 348, 349, 350, all in his name, they would empower ministers to delegate to such body that we consider appropriate power to provide officers under the Agricultural Wages Scotland Act 1949 with the ability to do certain things, and he took us through that, the abilities to inspect workers' accommodation, to notify concerns to the local authority. I just want to be really clear from the outset that I recognise the need, the imperative of ensuring that accommodation for agricultural workers is fit for habitation, and I've put that on the record, and it's something I absolutely agree with. But I can't agree that this amendment would provide the reassurance that I know he's seeking. First of all, unfortunately, there are drafting problems. The amendment creates a power to delegate a function of delegating, and it's not clear whether this amendment actually creates a function to be delegated. I know that that will be a frustration to Mr Leonard. I'm sorry to have to point it out. But on the more substantive issue, whilst dealing with routine or complaint inspections, members of the Agricultural Wages Enforcement Team, they will already report any concerns raised by employees on the condition of their accommodation to the appropriate local authority. Local authorities have powers under environmental law to inspect. But one thing I have to say is it's not clear to me that agricultural wage enforcement teams would necessarily have the expertise of inspections, given that wages is their remit. So I think that's something else we would have to look into. I can see Mr Leonard wants to take an
briefly, Richard Leonard.
Does the Cabinet Secretary not accept that the only powers that local authorities have got is around the infrastructure, including the parking arrangements on these sites? They've got no powers whatsoever over the state of the accommodation that these workers are living in.
Cabinet Secretary.
So I highlight the powers that local authorities have, alongside that the Agricultural Wages Enforcement Team already have in respect of reporting those concerns, to illustrate the picture as it stands. But I'm not conceding or suggesting that it's as good as it should be. And therefore, whilst I can't accept these amendments, owing to the slight drafting problems, owing to the fact that I'm not clear the wages officers are the right trained people to consider inspections, I can't support them. And I'll take one further intervention.
Briefly, Richard Leonard.
But there are three quite distinctive approaches to tackling this loophole. One is through the Agricultural Wages Board inspectors, but the other two are directly through local authority housing inspectors, and about introducing a tolerable standard to this accommodation where it is currently exempt. Does the Cabinet Secretary not concede that there is a route in the amendments 349 and 350 to tackle it?
Cabinet Secretary.
I'm afraid I can't accept that. Unfortunately, with 349, the duty to make bylaws, I don't think it's appropriate to require ministers to make such bylaws. This should remain a discretionary matter, which should allow for consultation with the local authority should there be any concerns about the adequacy of the local authority's own bylaws. And I note what he says about his freedom of information request, and I would be glad to see that detail. In respect of 350, this seeks to remove the ability of agricultural landowners in Scotland to set up the caravan sites to accommodate seasonal workers. I agree, ultimately, and the Scottish Government are fully committed to further engagement and development work to understand how we address the gap that 350 is trying to address. However, again, there's a problem here because we need to recognise that it needs to be addressed for all seasonal workers and not just for agricultural workers. So the totality of this is that, owing to drafting problems, the existing suite of laws as they stand, and the fact that the work needs to be for everybody and not just for agricultural workers, I can't accept that. I'm not going to take an intervention from Graham Simpson. I can't accept the provisions that Mr Leonard has put to me, but I commit to him to work with him on this. I want to see the freedom of information request that he's talking about. I want to see the photographs that he's referring that the First Minister was engaged with him on, and him and I and the Rural Affairs Secretary can sit down and we can look at this and work out what we need to do. Moving swiftly on, Presiding Officer, to combustible cladding. I recognise the intent behind Amendment 375. I can't support it as a proposed amendment which seeks to make change to subordinate legislation without consultation. The Building Scotland Regulations 2004, they prevent the installation of combustible external wall cladding systems on, quote, relevant buildings. This was made in 2022 following substantial consultation. If I can just give Megan Gallagher a little bit of detail, this resulted in a move to a threshold height of 11 metres for non-combustible cladding on blocks of flats and other buildings within the scope from 1 June 2022. The 11-metre height was established by the expert group and supported through consultation, and it aligns with the ability to firefight from the ground without the need for high-reach appliances. And the amendment, as she has put it to me, would set out would require non-combustible materials in external walls of all new homes, regardless of height or type. And this would exclude, for example, the use of timber cladding, which is common in many areas, and would also prevent the use of thermally efficient insulation, causing a risk to achieving good standards of energy performance. So, as with everything in cladding, the government's core ambition is to protect life safety, and we do that on the basis of expert advice that we have. I already have, I think, a date to come to committee and update members on cladding, so I will look to discuss that more with them then. But to conclude, Presiding Officer, I will be supporting Mark Griffin's 295 and would ask members to reject the others in the group.
Thank you. I call Maggie Chapman to wind up press to withdraw Amendment 3. Ms Chapman.
Thank you, Presiding Officer. The Chamber will be delighted to know I will just withdraw my Amendment 3. Thank you.
Thank you. The member seeks to withdraw Amendment 3. I call Amendment 71 in the name... I confirm everybody is content with the withdrawal of Amendment 3. Yes. I call Amendment 71 in the name of Maggie Chapman. Already debated with Amendment 3. Maggie Chapman, to move or not move?
Moved.
And I call Amendment 71A in the name of Maggie Chapman. Already debated with Amendment 3. Maggie Chapman, to move or not move?
Also moved.
Thank you. The question is that Amendment 71A be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on amendment number 71A in the name of Maggie Chapman is yes 8, no 100. There were no abstentions. The amendment is not agreed. Maggie Chapman to press or withdraw Amendment 71. The question is that Amendment 71 be agreed to. Are we all agreed? Yes. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. And the result of the vote on Amendment 71 in the name of Maggie Chapman is yes 24, no 84. There were no abstentions. The amendment is therefore not agreed. I call Amendment 175 in the name of Edward Mountain. Already debated with Amendment 152. Edward Mountain, to move or not move?
Not moved, Presiding Officer.
That is not moved. I call Amendment 72 in the name of Maggie Chapman. Already debated with Amendment 152. Maggie Chapman, to move or not move? Question is that Amendment 72 be agreed to. Are we all agreed? Yes. Are we all agreed? No. Parliament is not agreed. There will be a division. Members should cast their votes now. And the vote is now closed. And the result of the vote on Amendment 72 in the name of Maggie Chapman is yes 81, no 27. There were no abstentions. The amendment is therefore agreed. I call Amendment 281 in the name of Maggie Chapman, already debated with Amendment 152. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 281 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members who cast their votes now. And the vote is now closed. And the result of the vote on Amendment 281 in the name of Maggie Chapman is yes 24, no 85. There were no abstentions. The amendment is therefore not agreed. Call Amendment 282 in the name of Maggie Chapman, already debated with Amendment 152. Maggie Chapman, to move or not move?
Moved.
Question is that Amendment 282 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division of members who cast their votes now. And the vote is now closed. Point of order, Monica Lennon.
I would have voted yes. I couldn't connect.
Thank you, Ms Lennon. I'll make sure that is recorded. And the result of the vote on Amendment 282 in the name of Maggie Chapman is yes 24, no 85. There were no abstentions. The amendment is therefore not agreed. I call Amendment 34 in the name of Maggie Chapman, already debated with Amendment 152. Maggie Chapman, to move or not move?
Not moved.
That is not moved. I call Amendment 35 in the name of Maggie Chapman, already debated with Amendment 152. Maggie Chapman, to move or not move?
Not moved.
That is not moved. I call Amendment 73 in the name of Maggie Chapman, already debated with Amendment 152. Maggie Chapman, to move or not move?
Moved.
That is moved. The question is Amendment 73 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division. The members should cast their votes now. And the vote is now closed. And the result of the vote on Amendment 73 in the name of Maggie Chapman is yes 83, no 25. There were no abstentions. That amendment is therefore agreed. I call Amendment 36 in the name of Maggie Chapman, already debated with Amendment 152. Maggie Chapman, to move or not move?
Not moved.
That is not moved. I call Amendment 74 in the name of the Cabinet Secretary, already debated with Amendment 152. Cabinet Secretary, to move formally.
Moved.
The question is that Amendment 74 be agreed. Are we all agreed? Parliament's not agreed. There will be a division. The members should cast their votes now. And the vote's closed. Okay, the result of the vote on Amendment 74 in the name of the Cabinet Secretary is yes 82, no 25. There were no abstentions. The amendment is therefore agreed, which takes us to Group 8, rent controls out with rent control areas. Call Amendment 4 in the name of Maggie Chapman, grouped with Amendments 75, 76, 77, 176, 176A, 177 and 264. Maggie Chapman to move Amendment 4 and speak to all amendments in the group. Ms Chapman.
Thank you, Presiding Officer. I move Amendment 4 in my name. I have a number of amendments in this group on a range of issues, but particularly preventing rent hikes between tenancies and a definition of mid-market rent. This bill contains a helpful provision in Section 19, whereby there is a change of tenancy and there's been a rent increase in the previous 12 months.
Ms Chapman, if I could ask you, could I ask colleagues to keep their conversations either quiet or out with the chamber? Maggie Chapman to continue.
Thank you, Presiding Officer. The bill's provision in Section 19, whereby if there's a change of tenancy and there's been a rent increase in the previous 12 months, there cannot be another increase within the same 12-month period. This is a vital provision that means that changes of tenancies cannot be used to increase rents. My amendment number 4 applies this very helpful change to properties out with rent control areas, as there is no principled reason why tenants should not be protected in this way, regardless of where they live. Amendments 75, 76 and 77 address a technical but very important issue for tenants who want to challenge their rent. At the moment, rent adjudication may result in a higher rent than the landlord has asked for. As a result, some tenants will not challenge a rent increase that they might otherwise successfully reduce on appeal. Living Rent have looked at all rent appeals made since May this year, and in 22% of cases, that's more than 1 in 5, the appeal resulted in an increase beyond what the landlord had asked for, which is clearly a huge disincentive to challenging rent. The Scottish Government has said that the bill already rules out such an outcome, but hasn't provided the clarification it has promised. Given there is some uncertainty here, Amendments 75 to 77, which say that, for the avoidance of doubt, an order under subsection 1 may not state a higher rent than the rent specified in the rent increase notice, these are sensible precautions against confusion, and it makes 100% clear to rent officers that the requested rent increase is the absolute most that can be approved. Turning to Amendment 176, Parliament has made its will clear that there will be mid-market rent exemptions. That makes it even more crucial that we finally get round to defining what mid-market rent means. There is inconsistency over how mid-market rents affect affordability. As I said earlier, even the Scottish Government's own housing strategy, Housing to 2040, gives no definition of what mid-market means and understands that it is inconsistently applied. Amendment 176 provides ministers with a power to define mid-market rent and to determine how it is to be used, such as for rent control exemptions and housing supply programmes. This will bring much-needed clarity and consistency. Before I close, Amendment 177 is part of the package of amendments I have already spoken to, which seek to improve the way that open market rents are worked out. And I'll leave it there, Presiding Officer. Thank you.
Thank you. I call the Cabinet Secretary.
Thank you, Presiding Officer. Amendment 4 seeks to introduce further restrictions out with rent controls to the extent that where there has been a rent increase in the 12 months prior to the start of the tenancy, the landlord would not be able to increase the rent and the initial rent would require to be no more than the final rent under the previous tenancy. Now, this was lodged as an amendment at stage 2 and was voted against. And whilst I support restricting rent increases in areas where rent control has been deemed to be necessary, I cannot support seeking to place restrictions on rent increase in areas out with rent controls, i.e. where not considered necessary or proportionate. Turning to 75, 76 and 77, whilst I recognise concerns around the current rent adjudication process, where it is possible for the rent to be raised above the proposed rent increase, these changes are unnecessary because Section 22 and 23 in the bill already make the very change that Maggie Chapman is seeking to institute and will prevent the rent being set above the proposed in the rent increase notice once enacted. So there is no ambiguity in the current bill provisions as drafted, and I therefore can't support those amendments. Amendment 177 would require the rent officer or the first-tier tribunal, when making a determination of an open market rent as part of rent adjudication, to have regard to information collected by local authorities under Section 15 of the bill. Similar amendments were lodged at stage 2 and the equivalent to 177 was disagreed, and for the reasons set out then, we can't support it now. It's not clear why this is needed, given that the rent officer and the tribunal are already able to make determinations of open market rent in line with the requirements in the 2016 Act. Adjudicators have regard to all available data, regardless of whether there is a duty to do so or not. It's also unclear how such a process could operate and how often information would need to be collected for this purpose. So it would amount to an additional unnecessary burden on local authorities and give them a new role in supporting rent officers and the first-tier tribunal in the judicial process, which is not appropriate. So to the final amendments by Maggie Chapman in the group, 176 and 264, these would add a new section into the bill enabling ministers to define mid-market rent and the circumstances in which the definition must be used. Amendment 176A would convert 176 into a requirement to make regulations within 1 year as opposed to a power to do so. There's no clear reason as to why this power is needed or what it's to be used for. And as I have said, it's my intention to exempt, where appropriate, mid-market rent properties, but the power to define properties which are to be exempt already exists in the bill. And I therefore ask Ms Chapman not to press her amendments.
Thank you, Cabinet Secretary. I call Maggie Chapman to wind up and press or withdraw Amendment 4.
Thank you, Presiding Officer. I will press Amendment 4.
Thank you. The question is that Amendment 4 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Claire Haughey for a point of order.
Badge is in here.
Thank you, Presiding Officer. I was unable to connect my app and I would have voted no.
Thank you, Ms Haughey. We will ensure that is recorded. I call Fulton McGregor for a point of order.
Thank you, Presiding Officer. I was unable to connect and I would have voted no. I've also got a proxy vote for Colette Stevenson. She would have also voted no.
Thank you, Mr McGregor. We will ensure that those votes are recorded. And I call Angela Constance.
Presiding Officer, a digital voting connection could not be started. I would have voted no.
Thank you, Ms Constance. We'll ensure that's recorded. The result of the vote on amendment number 4 in the name of Maggie Chapman is yes 5, no 98. There were no abstentions. The amendment is therefore not agreed. I call amendment 75 in the name of Maggie Chapman, already debated with amendment 4. Maggie Chapman, to move or not move?
Moved.
The question is that amendment 75 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 75 in the name of Maggie Chapman is yes 29, no 81. There were no abstentions. The amendment is therefore not agreed. I call amendment 76 in the name of Maggie Chapman, already debated with amendment 4. Maggie Chapman, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call amendment 77 in the name of Maggie Chapman, already debated with amendment 4. Maggie Chapman, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call amendment 5 in the name of Maggie Chapman, already debated with amendment 3. Maggie Chapman, to move or not move?
Not moved.
Thank you. I call amendment 78 in the name of Maggie Chapman, already debated with amendment 3. Maggie Chapman, to move or not move? Thank you. I call amendment 78A in the name of Maggie Chapman, already debated with amendment 3. Maggie Chapman, to move or not move?
Moved.
Thank you. The question is that amendment 78A be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 78A in the name of Maggie Chapman is yes 24, no 85. There were no abstentions. The amendment is therefore not agreed. Maggie Chapman to press or withdraw amendment 78.
Press.
The question is that amendment 78 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 78 in the name of Maggie Chapman is yes 23, no 86. There were no abstentions. The amendment is therefore not agreed. I call amendment 176 in the name of Maggie Chapman, already debated with amendment 4. Maggie Chapman to move or not move?
Moved.
I call amendment 176A in the name of Maggie Chapman, already debated with amendment 4. Maggie Chapman to move or not move?
Also moved.
The question is that amendment 176A be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 176A in the name of Maggie Chapman is yes 43, no 65. There were no abstentions. The amendment is therefore not agreed. Maggie Chapman to press or withdraw amendment 176.
Press.
The question is that amendment 176 be agreed. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 176 in the name of Maggie Chapman is yes 47, no 63. There were no abstentions. The amendment is therefore not agreed. I call amendment 177 in the name of Maggie Chapman, already debated with amendment 4. Maggie Chapman to move or not move?
Moved.
The question is that Amendment 177 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The result of the vote is closed, and the result of the vote on amendment number 177 in the name of Maggie Chapman is yes 24, no 86. There were no abstentions. The amendment is therefore not agreed. That concludes consideration of amendments for today. The next item of business is consideration of Parliamentary Bureau Motion 19022 on committee membership, and I ask Graham Day, on behalf of the Parliamentary Bureau, to move the motion.
Move, Presiding Officer.
Thank you. The question on this motion will be put at decision time, and there's one question to be put as a result of today's business, and the question is that motion 19022 in the name of Graham Day on committee membership be agreed. Are we all agreed? Yes. We are agreed, and that concludes decision time, and I close this meeting.